We'll start from this side. Yes.
With the kindly of this court, my lords, contempt petition, learned single judge had passed orders to not to put up construction. My lords, the respondents are continuing the construction, my lords, contempt petition. Kindly be taken on the 8th, my lords.
18th.
Please.
Writ appeal matter, my lord. The matter was last listed on 28th of March, my lord. It's a fresh matter, my lord. It could not reach on the last date. The matter is urgent to 28th of May, my lord. There is some urgency, my lord. 3 days before vacation.
What is the urgency?
My lord, the matter is pertaining to recruitment of junior executive engineer of KPTCL, my lord. The recruitment is being finalized, my lord, in a week's time. Any day before vacation, my lord.
Where is the urgency? Application, immediately application.
It can be set aside if you succeed. Yes, yes, ma'am.
If the recruitment process is finalized, my lord, I'll lose my opportunity.
Soon after vacation, in the first week of reopening.
Contempt matter, my lord, your lordship sets for direction to the state not to take coercive action. My lord, that is being interpreted to mean that the school cannot recruit teachers. The new academic year has started, my lord, they are unable to recruit teachers. The endorsement given by the state is that there is an order not to take coercive action. Therefore, we will not even permit a positive action.
Fresh matter.
No, my lord, it's a pending matter. My lord, I filed the necessary applications.
You file application. Application. Interim application. 19th.
My lord, in this case, my lord, in view of urgency, my lord, appellant is aged about 80 years, my lord. Surcharge dispute, my lord. So the appellate authority has considered them on merit, disposed the matter. So thereafter, the respondent filed the writ petition, my lord. Without hearing the appellant counsel, my lord, the matter is remanded back to fresh consultation, my lord. Therefore, the proceedings is conducted by the first respondent, my lord.
It is remitted back.
Yes, my lord.
Then what is the urgency?
My lord, once it is considered on merit, dispose the matter, again it is evidence as fresh considered, my lord. Therefore, proceeding as time, my lord, because of his 80 years. old,
Reopening. First week of reopening. Second week of reopening. Yes.
This matter pertains to medical admission.
My lord, before vacation, my lord. Before vacation, my lord, kindly.
Not possible.
lord.
Not like to be taken. Yes.
Yes, my lords, this pertains to medical admission matter, my lords. The transferee colleges have stopped admissions to the medical second year MBBS students. Pursuant to the honorable, this honorable court's order, which was upheld, the transfers have been made pursuant to the NMC order also, because the transferor college had no approval from the NMC. They had taken 150 admissions without approval of the NMC. That was challenged before this honorable court, and this honorable court ordered for transfer of all the students, 150. Now,
You have to use mic. Why can't you have understand certain
Yes,
small
yes.
things?
yes, I'm sorry, my lords. Yes, my lords.
The
Pers-
medical colleges did not have the requisite infrastructure.
PIL.
No, individuals.
Now-
Challenge people being counsel.
Now the admissions. Yes, yes,
Wait.
I'm sorry,
Understand? The learning just says, shift all these students to other medical colleges. They're not-
Now only 30 students have been stalled. They have been prevented.
19th.
19.
My lord, the respondent Mines and Geology Department, they have issued notice to the petitioner of imposing a penalty of rupees 1 crore 60 lakhs without even considering the representation of the petitioner before them. In
23rd.
This honorable court has directed the appellants to reinstate the respondent forthwith to the services along with the 25% of back wages, my lords. But till today, after lapse of 40 days, my lords, till today they have not taken any steps, my lords.
After
A respondent is attaining the age of retirement, my lords.
when
There is
retiring.
in the month of June, my lords. There is a urgency, my lords. They have not
June.
complied the interim order, my lords.
In the first week of reopening. Yes.
35, 30.
My lord, for the complainant in this matter, my lord, this is contempt petition, my lord. My lord, accused is to hand over custody of the children for the last 10 days of April as per the order of the learned principal judge. But she is not giving a custody, my lord, which is why we have preferred a fresh matter, my lord. I pray that the matter be posted on Monday, my lord.
What is it about?
My lord.
What is it about?
Custody of children.
Custody of children.
Yes, my lord. Custody of 2 children, my lord.
Your mother,
For the complainant, I have got the order.
your mother,
No, no, my lord,
Father.
father, my lord, father.
19.
Lord, Madam, question Monday, my lord, actually, you notice issue of it.
19. Monday
Half day.
will not be time. Yes.
My lord, 19th, much obliged.
Lords, a writ appeal preferred by the BDM, my lords, I am appearing for respondent number 2. My lords, it's a date given matter. Status quo order was passed in the matter. However, my possession is being interfered, my lords. They are trying to dispossess me.
Matter is pending.
My lords,
Yes, pending.
Pending.
It's pending.
please, my lords.
After it.
Lords, any day before vacation, my lords.
Yeah, hard press. of
Interim
finding
order.
hard press. Interim order.
Interim. Yes.
The appellant, my lord, the appellant is a registered trade union. The learned single judge had granted a interim order, my lord, directing for referendum, but that order has been vacated, my lord. Hence, I've preferred the instant writ appeal.
Urgency.
My lord, there's some urgency, any date, even after vacation, any date,
After vacation, second week of.
any date, my lord.
Lord, in one matter, in the PL, I appear for the respondent number 41 society, my lord, where
Number? Serial number?
Not.
my lord,
Not-
I'm moving.
Ah.
In one matter, PL matter, I appear for the respondent number 41, which is a society formed for upliftment of the downward classes. Their layout has been formed by the government and 132 sites have been given and registered shaded have been done, my lord. Now, third respondent forest department, they are trying to encroach upon our site, saying that
Okay.
farmland.
Once you remove the office option, we list.
Will come.
After vacation. Not
My
now.
lords, if I may mention, serial number 27, praying for time, my lords. There's a bereavement in the family of my counsel, of the council.
27.
Yes, ma'am. I'm for the appellant. I've informed the respondent counsel.
You want after vacation?
My lords, next week, 2 weeks. My lords, we'll close the matter and
After vacation.
My lords, serial number 38, my lords. The matter was listed day before yesterday, my lords. Learned AG had appeared. Serial number 38, my lords, 155 of 24. My lords was pleased to adjourn the matter post vacations for conducting of elections. I think by mistake it's posted today again, my lords. So it was adjourned for post vacation, my lords.
38.
Please, my lords.
Same matter.
Please, serial number 38.
It may be passed over, my lord. Senior wants to make submission on this. my lord.
No, the
Learned AG had appeared. They had also
council
appeared
is
day
right, the
before yesterday.
cooperative society.
Please, my lords. My lords adjourned it post
Senior,
vacation.
Beyond vacation.
Grateful.
My lords, kindly, my lord, serial number 28, 29 and 43 are
Selected matters.
Yes, my lord. Yeah, request, my lord, court accommodation, my lord. 28, 29 and 43, my lord. I have informed.
For the appellants, my lord.
43.
Probabilities, my lord, normally would not have opposed, my lord. The other side is, my lord, there is a government property, they are about to make constructions. Any date, my lord, possible before the vacation? 18, 19.
Relay is there.
Any expect 18, 19th or any day?
Oh,
Yes.
give me that.
April 18, 19th, let him file objections.
After vacation. Second week of.
After vacation.
Second week
Please,
after.
Could there be a date at least first week, any date can I
Right
expect?
from
First week.
you will-
Any date, my lord, so that convenient. my lord.
31st. 31st May.
please. Obliged.
Serial number 50, my lord. 50. Serial number 50, my lord. I need 2 weeks recommendation to comply office. 50.
All office objections matter which are starting from 44 probably. 44. Yes.
Number
Common order,
44 onwards.
office objections shall be removed within 3 weeks, failing which the matter shall stand dismissed automatically without reference to or order of the court.
Number 44 to
From 44 onwards.
57, 3 weeks like peremptory order. But 30, 31, 32 before other bench. Contempt matter, seal number 1. Shashi Kumar, yeah.
I am appearing for complainant, my lord. The accused BBMP disobeyed the order annexed at G, my lord. The respondent BBMPR para number 8 directed to give effect to the confirmation order dated 8/8/2012 passed under section 321 clause 3 of 1976 Act within 45 days.
Notice.
Already 1 year is over, my lord. 1 year is over.
We have noticed that, notice. Second week of
Lordship's permission, my lord. I take notice.
11th June.
You appear for both the respondents.
Yes.
We are accepting notice.
Panel.
Yes.
I am serving the copy, my lord.
11th June. Seal number 2, so PL matter. Krishna is back.
Lord,
Commissioner in
appear
this
for
matter.
respondent.
First is the case wherein a temple situated at Perdur, my lords, at Udupi district. The northern and western portions of the temple wherein the car street are laid, my lords, is proposed for extension of the highway and, my lords, by extension of this, my lords, 169. There is an inherent threat that, my lords, the entire structure of the temple will be affected, including the Nagavana, which is surrounding the temple, my lords. I draw the attention of this honorable court to the Vastu Paridhi of the temple, which is produced at page number 59.
Widening of road itself is a public interest.
My lords?
Widening
Yes,
of road.
widening of the road itself may be public interest, my lords. Sufficient judgments of the Honorable Supreme Court have also been established, my lords. But one aspect which I want to bring to the notice of this Honorable Court is that there are two concepts of road development, my lords, which have been proposed by the first respondent themselves. A guidelines has been published under the NHAA Act 1956, my lords, which states that the guidelines which have to be followed while widening of the roads. There are two concepts there, my lords. One is brownfield alignment and the second one is greenfield alignment.
Photograph at page 58. This is the road which is sought to be widened.
Yes, my lords.
Then why?
No, my lords, I bring to the attention of this honorable court to page number 61, my lords.
It doesn't touch any temple property or temple.
It is completely touching the temple property, my lords. I draw the attention of this honorable court to the car street of the temple, my lords. It is a car street of the temple on which the road has been proposed. My lords, in earlier days, whatever car street has been established for a temple belongs to the temple. But, my lords, for the sake of public utility, that car street was being opened for being utilized for public purposes. Now, my lords, whenever the car street is there, it is the inherent authority of the temple to block the car street. I bring to the attention of this honorable court to page number 53 and 54, my lords. It may be seen that this car festival, whatever is shown here, my lords, is a monthly car festival. On every Sankramana, this is the amount of crowd which gathers in the temple. And now, my lords, by the formation of this highway, this car festival will go away. And second aspect.
Okay. When land was notified for acquisition.
Yes, my lords.
What was the objection filed by the temple?
Yes, my lords. We have filed the objection which is at page number 62, annexure H, my lords. On 19/12/2022. Page number 62. 62.
52 is photograph.
62.
This objection has been signed by about 179 devotees of the temple. Translation 64, my lords.
Devala.
Minutes.
Where have you stated in your representation this property belongs to you?
Lords, it has not been stated because it has been given by the temple devotees, my lords. They do not have technical knowledge and they have not stated it. But now, my lords, I have also made the government a party to the proceedings, that the HRNC department, my lords. The temple now comes under the HRNC department. And now, my lords, every car street which has been established, which is on the peripheral of the temple, my lords, is established keeping the temple as the centric situation. Otherwise, such roads would not have come into existence at all. Now, having the temple as a centric situation, a car street comes to be established, not only in this place, my lords, every temple, wherever it is established in South India, it is established keeping the temple as centric. It is called as Parikrama Paridhi, my lords. So, on that Parikrama Paridhi, but because it is not utilized for car festival throughout the year, my lords, it is opened up for general public's traveling, including movement of car and other vehicular transport.
Where have you stated? This is Parikrama Pradesh.
My lords,
and it belongs to ownership of the temple.
My lords, but the notice, whatever has been.
You have to answer the.
Yes, it is a
You
specific
can't go on
question, my
arguing
lords.
the things like
My
that.
lords, so far as the objections are concerned, it has been filed by the devotees, my lords, who are laymen. They do not know the technicalities of the issue, but whatever the
temple
law.
knew. Temple knew everything. Temple knows where to come, where to go. Why it did not file the objections?
My lords, it has filed the objection, my lords, but.
When the objection show that it belongs to you, one sentence.
My lords, it has not been stated.
Then what can be done?
But my lords, even today, even the acquisition notification which has been given, my lords, entire property for acquisition is shown as private property. It may be seen, my lords.
All right. Always acquisition is of private property. It cannot be acquisition of public property is unknown to law of acquisition. Question is, where have you stated this property belongs to you, to the temple?
My lords,
Says, tell, all right. People did not know. You are before the court. In which paragraph you have taken up that contention? This property belongs to the temple. All people are ignorant, but you are not. Show that.
my lords, I have stated that it is in the proximity of western and northern doors of the temple, my lords.
So many things are in
First,
proximity. Question
inherent-
is, where have you stated this property belongs to us? And you cannot
Lords,
acquire it
my-
that way.
my
Where have you
lords,
stated?
Paragraph number 2 in page number 7, my lords.
There are two.
That is subparagraph number 2 of paragraph number 8. It is submitted that there is a temple for Nagas along with Chitrakuta situated in northern side of the temple where the devotees perform special observations during the auspicious occasion of Naga Panchami and Shashti. There is a profound belief that the said observations are yielding result to the long pending so and so. Further, in the nearest vicinity of the particularly the residents of the village, this is the only temple which is available for Nagas, which is considered to be holy. Further, the said Paradur is low-lying structure and other. I have said that this Naga temple is going to be demolished, my lords. It belongs to the temple.
Are you going to demolish the Naga temple?
My lords,
As per the proposal.
You want to
I
go on
apologize,
again
I
on
apologize.
irrelevant thing. Yes,
lords, now, my lords, we have only acquired the properties. I am appearing for respondent number
we
1.
want to ask you.
Yes,
Do you want to
yes,
dismantle that Naga temple?
lords, I have to seek instructions, my lords. I have not. Lords.
If that Naga temple is saved,
Yes,
perhaps much of I would go.
yes, I'll, my lords, take instructions.
Because law is where temple, mosque, church properties are involved and they come in the performance of essential religious practice, then generally you have to work. It is not that they cannot be acquired. You have to explore the possibilities of going for a deviation. That exercise, unless that is done, there are judgments which have invalidated the acquisition process. Though petition is badly drafted, don't worry about it. We have understood. Now, if you say we are not going to touch the temple,
My lords, will call
things
this
will be
matter on
over.
Monday or
Page
Monday.
58 is Naga temple.
Page 58 is the Naga temple, my lords.
Then you can save this.
Yes.
Then you can save this.
If you make a statement that will
Yes.
not touch this temple,
My lords, one more simple aspect I want to touch upon, my lords. Page number 60 and 61. 60, my lords, is the proposed road which is now under question. And 61, my lords, is an alternative road which can be laid, which will be even of a shorter distance, my lords.
see, these are the matters relating to road engineering.
Yes, my
We
lords.
have taken in two judgments with that Hubli matter, flyover. We have taken a view in matters like this. We are not engineer, we are not engineers.
Yes, my lords.
The bodies will, expert bodies will take the decision.
Yes,
We
my
can adjudge the merits of that decision in a very limited way. Because we cannot run, a court cannot run a race of opinions with the executive. Anyway, now if he says that temple will be saved, everything will be over. Yes, you have to make a statement.
May I request my lords to post this matter on 15th or 16th?
The boundary of the temple appears to be inside the other building. So you try. That much we are giving indulgence.
I'll take notice for R1, my lord. So
Notice
R2
written
panel
as-
advocate may be there.
My lord, R4, I take notice.
Yes, Chief, shall not be, temple shall not be touched.
Notice, heard, notice returnable.
You appear for first
First
respondent.
respond.
30th.
Two and
Two, my lord, Shobit Shetty appears.
Shobit Shetty
Shobit
appears,
Shetty.
panel council appears for 2, 3,
My lord, I appear for
4 and 5 you appear for.
Four and
4
five.
alone.
Four and
5
five.
also.
4 and
4, notice to 5.
5.
Notice, returnable to respective councils, accept the notice.
Shobit Shetty.
Commit Shashi.
Raj.
Additional government. On the returnable date, the respondents will take instructions to apprise the court whether the road laying will take toll of the Naga temple, either in part or fully. 38.
Great.
obliged.
See that it is, if it can be.
I will, my lords. I'll take instructions and make my submissions, my lords. In fact, I tried to contact them also. my lords.
Everybody goes happy. That is.
Please, my lords. Fact, my lords, 2023, Honorable Supreme Court held that, my lords, it is for the authority to take a call, my lords. Anyway,
Can save the temple.
yes.
You have to be a bit careful when religious institutions, shrines are involved.
Yes.
My lords, one more submission is that, my lords, the manual categorically instructs that there are supposed to be certain
We have held that,
precautions.
we have held that manual to be executive instructions and not binding on anybody in that decision.
Great.
Number 3, the green bench matters. Mr. Sakil
Lords,
here.
I am appearing for the petitioner in this case, my lords. Lords, the respondent has issued the notice, demand notice, my lords, for the royalty and
Next, G.
without hearing the petitioners, my lords.
Where is that notice?
Page 14.
There is a batch of writ petitions, my lords.
In identical matters, what we have done, dismissed.
Notice has been ordered, my
Has
lords.
he been heard in the matter?
Yes, my lord, every year we conduct, it is a quarry in currency. Every year we issue audit report. If he is aggrieved by the audit report, he can file objections. Or he can file revision before the revisional authority. That is what the view taken by the coordinate bench of this honorable court. And there are subsequent demand also in the year 2024. What is challenged is the audit report of the year 2022.
Revisable order also,
Yes,
53.
53. $16 crores is the demand.
16.
16 crores.
16 crores is the
In the
demand.
year 2022, it was 15. Fresh demand is issued in the year 2024 also, on 5th March 2024.
My lords, there is
So
a
this
batch
order
of
is
writ
based on the
petitions,
audit report.
but then
But the audit report can form the basis of taking action. You can go 53. That's all.
53 revision lies.
Yes, yes.
And you will not take up a contention that it is not a revisable order.
No, my lord. It is a reversible order because the order is passed by the competent authority.
my lords, unilaterally, they have passed the order, my lords, without hearing the petitioners.
But you have seen the judgment. Have you
Yes,
seen
my
a
lord,
copy
I
of
have
the
seen,
judgment?
yes,
I
my lords,
served.
my lords, Even though, my lords, there is a batch of writ petitions pertaining to the same, my lords, around 20 matters are.
We'll duplicate this order in all those 19
My
matters.
lords, maybe connected to that matter, my lords.
In this petition, the petitioner, in this petition filed under Article 226 of the Constitution, the petitioner has sought to challenge notice dated 3/9/22 issued by respondent to dash the Deputy Director of Mines and Geology. Mangaluru, Dakshina Kannada. Whereby sum of rupees 15,05,68,209 has been demanded from the petitioner towards the arrears of royalty and dead rent along with the penalty. In respect of license given to the petitioner for quarry number DKD number 168, operative from 21/1/1990 for a period of 10 years. Learned government advocate appears and submits by citing a precedent in form of order dated 13th February 24 passed by the coordinate bench in writ petition number 4819 of 18. That in that case, the challenge was identical. Challenge was to an identical. Challenge was to a similar order. The demand of royalty and dead rent, as in the said case, has also been, in the present case, pursuant to the audit report. Full stop. The coordinate bench observed that the petitioner could file his objection to the audit report paragraph. It is further to be noted that the petitioner has remedy available to file revision application under Rule 53 of the Karnataka Minor Mineral Concession Rules 1994. In the proceeding, the court is not inclined to entertain the petition. Full stop.
Liberty may be reserved. Liberty may be reserved to.
Full stop. At this stage, learned advocate Mr. So-and-so, so-and-so. What is your good name? Sachin BS. Yes. Request that the petitioner may be granted liberty to file revision application. Such liberty is granted. However, the court does not express any opinion on the merits of the controversy between the parties. The petition is accordingly disposed of. Has not entertained. Disposed of is not entertained.
Number 4, writ appeal matters, fresh.
Appearing
the
class
appellant,
youngest
my lord.
respondent.
Original order under challenges of the year 2015, my lord. And the original order which is sought, which has been challenged, my lord, is of the year 2015. And the order was passed under senior, invoking the powers under Senior Citizens Act, my lord.
Correct. Section 23.
Yes, my lord. He deceased, my lord. My lord, the deceased KB Nanjappa had 3 sons and 4 daughters, my lord. And in the year 2014, my lord, he had executed a gift deed and also a will, my lord. Subsequently, my lord, the father, that is KB Nanjappa, filed a complaint before the assistant commissioner alleging that the gift deed has been obtained by way of fraud, my lord. On that basis, my lord, invoking the provision under section 23(1) of the act, the gift deed was cancelled, my lords. My submission, my lord, is under Senior Citizen Act, there are 2 aspects, my lord. One aspect is a person saying, yes, I have executed a deed. There was a condition in that deed and that condition has been violated, hence cancel it.
The other situation would be the person saying, I had never executed a deed at all. The deed has been executed by way of fraud. My submission would be, my lord, if a person alleges that a deed has been executed, but a condition in that deed was violated, then Senior Citizens Act can be invoked, my lord. But when a person says the deed itself has been executed by way of fraud, my lord, it is for the civil court to entertain the matter to decide whether the fraud had happened or not, my lord.
So will was executed in your favor.
My lord?
Will was executed in your favor.
Gift was executed. Yes.
Gift. And now you are saying that it is by fraud.
Not me, my lord. I am the son. The order was passed against me in favor of my late father. Father had gone to the assistant commissioner alleging that
When he died,
he died in the year 12/2/2017, my lord.
when matter was pending.
No, my lord. Order was passed in the year 2015. He died in the year 2017, my lord. But had that been the situation, my lord, this whole the dispute would not have arisen, my lord. What happened was, subsequently in the year 2019, one of my brother goes and files a police complaint referring to the order of this court, where the assistant commissioner observes that probably the deed has been executed by a fraud. And taking that observation, my lord, there is another will, my lord.
What happened to appeal?
My lord?
No appeal was filed.
No appeal. Writ was filed. Writ was dismissed on the grounds of delay, my lord.
You could have filed appeal.
My lord, see, yes, let me explain, my lord. Once my father himself filed a complaint, my lord, complaint against me, my lord, and it was gift deed was cancelled. I had no intention to challenge it also, my lord. I had no intention to go against my father, my lord. Subsequent to my father's death, one of my brother goes and files a police complaint saying the assistant commissioner has recorded in his order that probably this gift deed has been executed by a fraud. There is another will also which has been executed. Most probably that also has been executed by a fraud. So kindly take action.
The question is, suppose if you have no issue as to the invalidation of the gift, we will record that here. That will go back to property, will go back to the estate of the deceased.
Yes.
That's the law.
Yes.
But the observation, my lord, there's an observation made by the assistant commissioner, my lord. Kindly see page number 42, my lord. The assistant commissioner observes
about fraud and other things.
How he comes to a conclusion is he says the gift deed, my lord, there is left thumb impression. But before me, the complaint has been filed by making a signature. Here he can sign. Then why didn't he not put a signature there?
On the ground, very well. But now you say you have no issue for invalidation on the invalidation.
Insofar as the gift is concerned, insofar as the observation, my lord, that the gift has been executed by a fraud.
The observations you can dilute so that the property will go back to the estate of the deceased.
My lord.
Otherwise, also now it has gone to the estate of the deceased.
My lord, this is connected with the criminal matter where the
Well, you
punishment
can work out your
prescribed is
remedy
10
there.
years punishment or life imprisonment. Both are connected. Once my learned counsel completes, I'll just give the connection why they have approached this honorable court after 5 years from date of passing the order and after 3 years from the date of death of the executor, my lord. Let my
What happened to criminal matter?
criminal matter, the protest petition is still pending, my lord. Once the police have filed the
C report is filed and
C
you have filed
report,
protest.
once again that was rejected by the honorable trial court and directed the police to conduct further investigation properly. Now again, they have succeeded in getting the B report submitted. Once again, the protest petition by way of objection is being filed. There is pending disposal, my lord. Even before the court has issued any summons, it is settled principle of law in criminal matter that when the protest petition is filed, unless and until the summons is issued, the accused has no say, has no right at all to appear before the court or to question the same. But this case has been filed, the writ appeal has been filed only to see that, to take the stay in this matter and approach the trial court to say that the matter is pending before the
We have
High
understood
Court.
what
Yes,
you
sir.
are saying. It is in the light of Rupen Devol Bajaj versus KPS Gill, that protest petition, etc. We are
Yes,
not on
yes.
that. How the assistant commissioner could have recorded a finding as to the gift being obtained by fraud? That's not his domain. He can invalidate a valid gift. That we are telling.
But I'll give the citation where Supreme Court judgment where two tests has to be applied to validate the order passed by the learned assistant commissioner to invalidate the gift deed being made, my lord.
Justice Oka's, Honorable Justice Oka's judgment.
Yes, my lord.
This Kevin Achappa is your brother.
Yes, my lord. All the respondents are my brothers and sisters.
He
Page
approached-
5, para
he
12, my lord.
approached the commissioner in 14.
Now there is a dispute because on the same day another will has been executed. That will has been challenged in the civil court where this ground has been taken.
Section 23. Civil rights, they have to work out elsewhere, fraud, etc. They are not the conspectus of, within the conspectus of section 23. Focus of says, jurisdiction needs to invalidate the Yes, invalidity is not, the invalidity of a gift, which is treated as a contract, is not on the ground of coercion, fraud, undue influence and mistake.
Yes.
It is not on that ground. That ground could not have been treated by the Assistant Commissioner under section 23. 23 gives power to the Assistant Commissioner to avoid a valid gift also. That's the law.
My lord,
Therefore, he could not have recorded a finding as to whether the gift deed is obtained by fraud, etc. That cannot be the ground at all. That the civil court can do. That's the law.
my lord, my learned friend is misleading the court. The test being applied by the assistant commissioner is in accordance with law. There are two conditions, as I said, my lord. There must be an express condition as the principle laid down by the Supreme Court in the gift deed, and the assistant commissioner have to conduct the investigation or examination and to see whether the donee has refused or neglected to look after the senior citizen. My lord, please come to page number 67 of the gift deed, my lord.
AC cannot say it is fraudulent. That means that and property will remain with them. Updation of law. The correct position stated law is this.
My lord, I humbly request
Yeah,
to
already
come to
right.
the court to
It's a
page
writ appeal.
67. There
Cannot
is
go
an
ahead.
express condition, my lord. And page number 41 of the Assistant Commissioner judgment, my lord, which is very important, which he has done the inquiry in accordance with law, satisfied himself that the donee has refused and neglected to look after the donor.
That
On this
remains.
basis, he has
That
quashed.
remains.
My lord, page
Why
number
can't you un-
41.
Why can't you understand?
Yes, my lord.
You want that property to be retained as the estate of the deceased. Nothing beyond that.
No,
But
my
how
lord.
can-
After the
Criminal
it
case
has
will
been
go on
cancelled.
independently. Criminal cases will go independently where you have filed the protest petition. Because the police people have filed B report, you have filed protest petition in the light of law declared by apex court in Ripendala.
And there is no connection between this case and criminal case,
That
my
case,
lord.
that independently will go.
Yes, ma'am.
But the findings which partake the character of fault grounds, those findings he cannot record. That's how we have held on.
My lord, I am coming to the admission of the respondent where he himself has accepted that the respondent has also admitted that now the complainant is residing in the house of his elder brother K.N. Prakash, page number 41, my lord. At all, if the complainant was residing in his house of the respondent since from several years,
Yes, partially allowed.
what are the reasons for the complainant to shift his residence to his elder son Prakash, with whom the respondent is having several disputes? Further, why the respondent has not made any attempt to take his father to his house since from all these months?
All
The
that will
attitude of
remain.
the respondent creates doubt about his intentions with regard to the maintenance of his father.
It will remain as it is.
We are not touching your rights in that sense.
But we
Lord.
dilute only. the
We will
grounds
only
of-
say that the commissioner could not have recorded a finding that it was executed by fraud.
That's all. Only that finding.
That we are diluting that part of the order.
My lord, that is mentioned in para 13, para 12 of the AC Commissioner.
Then you can take your civil remedies.
That's all.
either of the party. We do not know will take or we will not take.
But
We
the
are only-
examination has been conducted
While-
as per the test.
While disposing of this appeal, we are only saying that the finding recorded by the commissioner under section 23 cannot extend to the observation that this gift deed was executed by fraud.
It has not been mentioned that it has been executed by fraud, my lord. The
is
second test, kindly appreciate, my lord, the
page?
second.
Para 42, page 42, my lords.
Page 40.
Para 13.
Para 13 and 14 both?
Yes, my lord. In that para 13, what it says is, further the said gift was executed and the complaint is filed. On perusal of the said gift deed alleged to have been executed by the complaint in favor shows that complainant has put his thumb impression on the registered document.
Yes.
But at the time of filing, the said document has put his signature as the complainant and also put his signature in the order. When the complaint father is capable of subscribing his signature, what was the necessity of putting his thumb impression on the alleged gifted? And this creates serious doubts about the consent and knowledge of the complainant with regard to the execution of the said deed in favor of the respondent.
So these are the element of fraudulent.
My lord, my humble submission, my humble request to look into para 12, my lord. Examination has been conducted in accordance with law. This is further observation being made in para 13 and 14. But in para 12, the donee himself accept that the senior citizen was residing with the elder brother, not with him. It clearly shows that he has refused and neglected to look after. From the date of passing the executing the deed, after 11 months, this complaint is being filed. For 11 months, he was with his elder son. Then he has filed the complaint before the assistant commissioner. What made him to send to his brother's house, my lord?
Heard learned advocate, Mr. What is your good name? Vikas. For the appellant, our learned additional government advocate, Mr.
For
Nilofar.
respondent number 1.
Number 1, Nilofar Akbar, number 1, and learned advocate, Miss
Usha Prakash for R2A, my lord. Only R2A.
Usha so-and-so R2A, comma at length. Resort purchase orders.
Obliged.
That's I appear for the complainant. The contempt had been filed for non-payment of the amounts due to the complainant, my lord, by the PWD department. Now the PWD department has passed a resolution stating that they will pay the amounts due to me.
We have filed.
And they will seek a permission from the government for release of the funds. However, my lord, the time frame has not been fixed in this matter.
Yes.
My humble request is that my lords may kindly fix a time frame for release of the funds from the government and for payment of.
We have considered and passed the order. During the next release, it will be released. The amount
We
will
should
be
tell
released.
within what period you are going to do. You can't ask, just pass an order. With that order, he cannot go in
No,
market and buy
within
brinjal.
4 weeks. 4 weeks will.
4 weeks.
Till such time,
the complainant original petitioner was
till such time the contempt may be kept pending.
still entitled to receive certain sum by a single judge as per his judgment and order dated 20th October 22. Also, the direction was issued to respond 2 and 3 to consider the claim of the petitioner and pass approved orders. Today, when the contempt
No, we
application
have
is-
filed complaints affidavit.
complaint application comes up for consideration, learned government advocate Mr. Mahindra stated that the payment is processed and only
An order was passed on 3/4/2024.
3/4.
3/4/2024.
Stated that the order, necessary orders has already been passed on 3/4/24 and the question of payment is under process. And the only stage left is the approval of the government. Approval of the competent authority at the level of the government. Full stop. In view of the above, there is a compliance substantially acted upon. Full stop. Learned the government advocate further makes a statement that the actual payment will be made within 6 weeks from today.
My lords, I may be given liberty to revive the contempt
Full stop. The above statement satisfies the complainant appearing to learned advocate Mr. So and so so and so. Full stop. Contempt proceedings are closed in view of the above statement of learned government advocate. Full stop. Liberty. It is observed that non-compliance of the rest of the part aggravated contempt. As above, shall expose the respondent to contempt again. Grateful.
Seal number 6.
For the complainant in
Of
this case,
compliances, contempt, seal number 6.
Accused. Weeks time may be granted, my lord. I'll be- Weeks time.
Will do. 2 weeks. 2 weeks.
Seal number 7. The Vijay Tarnay.
Connected writ appeal, my lord, I have filed a petition for condonation of delay. But in similar facts, my lord, your lordships have already held that.
Not 3
Wait
days.
await the decision of the Honorable Supreme Court.
Go to 20.
Delay we can condone. You
My
appear
lord,
for the
I'm
landlord.
also appearing for the BDA itself,
BDA.
my lord. In a contempt petition, I'm appearing for the respondent, accused, my
A
lord.
notice has, I may permitted to serve a notice on the complainant's advocate.
25th June. 25th June.
Notice has to go.
Yes, I may permit.
Notice 25th June.
You appear for
Respondent number 1, my lord.
1.
Notice written on 25th June, learned government, additional government. So and so, so and so, except notice.
A for CD.
May seek one indulgence. my lord. I may permit it to serve on a complainant's advocate.
In addition to taking
In
legal
addition to
steps.
that.
In addition to the taking of the summons, learned advocate for the complainant is permitted to serve.
The advocate appearing.
Learned counsel,
Single judge.
respondent,
Please.
who appeared in the main proceedings.
Oblige.
Obliged.
Seal number 8 with the Jyoti.
For complainant, your lordship, the respondent has to file a reply for non-compliance of the order by.
Lord, we have considered and passed an order on 17/11/23. Direction is to consider their representation. We have considered, Lord, I'll
And rejected.
reject it.
Your lordship, let them file a copy, my lord,
I-
and serve
give
a
copy.
copy. So that I
I'll file
can
complaints.
verify it and I'll file my objections. if any.
It has been considered.
Learned government advocate states that the direction to decide the representation has been complied with and the order is passed by the competent authority. Copy of.
On 17/11/2023.
Copy is annexure.
Annexure R1, I shall file the complaints.
Dated or
Dated 17/11/2023.
decided on 17/11/2023.
3.
Copy of which shall be supplied to
The complainant or
the
counsel.
complainant.
I'll file my
Full stop.
objections if any, I'll review it. your lordship.
Only in order to verify the compliance. Time is granted to the complainant. Full stop. The contempt application may be listed on 19th of April at 2:30. Only for that purpose. Otherwise, it is 90% disposed.
Kindly. I'll verify if ever there are any objections, I'll file it, your lordship.
You take instructions.
And I'll take instructions.
Seal number 9.
No.
Submit.
For the complainant, my lords.
Interim order.
My lords.
It is interim order.
It is a provision of water connection, my lords. It is not anything else but provision of
Is
water
it an
connection.
interim order?
Yes, my lords, it is an interim order.
Then further you can say.
My lord,
But you
I'll
should
file
answer
my
the court's
reply.
question.
I'll have to file my reply, my lord. I seek some time to file my reply. I want to file a reply to you.
We won't permit you.
The interim order, my lords, will see at page 61.
Where is that order? Page 61.
Page 61, my lord.
The order which is brought under the jurisdiction of this court under the contempt of 1971. Dated 6/2/23, figuring at page 61 of the compilation of this contempt application is evidently an interim order. Full stop. The main writ petition is pending before a single judge. Full stop. When the order paragraph is interim in nature and now final rights are crystallized, comma, and further when the dispute is at large before learned single judge, comma, the court is not inclined to invoke the contempt jurisdiction. Full stop. The complainant is at liberty to approach learned single judge in the proceedings of the writ petition to work out its rights and remedies. In accordance with law, this contempt petition is disposed of as not entertained on the aforesaid ground alone.
Great. So number 10, Mr. Sundaresh, HC.
The complaint in this case. With your lordships kindly, my lords, I appear for the accused number 3. My lords, a review has been filed in as much as the order of which contempt is being alleged. My lords have passed the order. My lords sitting single have passed the order. We have filed a review and my lords have also issued notice on the review also.
All these petition is pending.
Please, the review petition, my lords have heard us and issued notice as well. These are the.
So we'll put up application after.
Your lordship may kindly see the review has been filed.
Review is, I have heard.
Only on the ground that they are not liable to execute the sale deed. Only the BD has to execute the sale deed.
No, my lords. My case before this honorable court was
We'll
that
simply say
unless until an order.
25th of June. 25th of June.
Please, deeply obliged. Deeply obliged.
So number 11.
And I am appearing for the
Radhakrishna
complainant.
Varla.
The counsel for the accused have not filed the reply.
Reconsideration.
Please, my lord, we have issued notices to the complainants and some of the complainants have replied back to us with information which is not in accordance with what we had requested. We have again written back to them asking us to give us the information as sought for, failing which will proceed to pass orders. The inquiry is going on, my lord, as directed by your lord.
When will you complete the inquiry?
My lords, because of the election duties, the officers are unavailable.
Now we
My
are
request
asking a
for
question.
second week of June, my lords, if I may kindly
Second
request.
week you will do
Second week
that?
of June, my lords.
We'll record that. If they do not do, you can revive.
May I be permitted to place the memo on records, my lords, to show the notices have been issued to the complainants.
Solid. We will say that you said in the second week of June, it will be over.
Please, my lords.
Radhakrishna Holla. Yes. You are Radhakrishna.
No, I am Jawra. This is regarding consideration. Set aside particular resolution. Also, they say before in the second week of June, they will.
May I just seek an indulgence, my lords? The order passed, my lords, is with respect to 100, the order which has been set aside is with respect to 113 persons, my lords. Now, the first batch of inquiries, my lord, is being done for those.
Contempt application arises out of judgment and order dated 15th March 23 of law on a single judge in the writ petition number 49448 of 19. Paragraph, while allowing the writ petition in part, resolution of the Bengaluru Development Authority, whereby the allotment of site was cancelled, came to be set at naught. The matter was further directed to be remitted for reconsideration afresh by allowing participation of the petitioners and by supplying the copy of the police report to them. Full stop. There was a time stipulated for completion of such exercise. Paragraph. When the contempt application comes up for consideration, learned advocate Mr.
B. Vachana.
B. Vachana stated, appearing for Bombay Bengaluru Development Authority, stated that the exercise as directed by learned single judge shall be completed on or before 30th June. 30th June.
Please.
30th June.
Please, my lords,
30th
obliged.
June. Full stop. This satisfies the complainant appearing through learned advocate Mr. So and so, so and so. In that view, the contempt proceedings are closed. Non-compliance of the statement made before learned counsel, before the court by learned counsel shall expose the authorities to contempt jurisdiction again.
My lord, the inquiry, my lord, will be with respect to the complainants, my lord, because the 113 persons, we are doing it in batches, my lord. So the entire order compliance will take a much longer time for the reason.
Therefore, you said second week. We gave you end of June.
Individually, the notices will have to be sent and individually they are called, my lord. So the inquiry.
15th of July. Within
The
15th of July,
completion-
you have to do. Some timeline has to be fixed.
For these complaints, we'll do it within 30th of June, my lords.
30th of.
Because there are 113 persons in all for that order, my lords. That's the reason.
Anyway, with this is only with regard to the.
Complainants, my lord. That's all my indulgence I'm seeking, my lords.
Seal number 12,
Population.
Sunil Kumar Patel.
For complainant.
So that appear for the accused.
12, 13, 14, 15 are connected. my lord.
Same.
Lord,
Same.
my.
There are two
my
more
s-
matters, my lords.
Lord, I'll file my reply. There are a lot of Kannada documents and translation is in the process, Lord. May I request your lordship to kindly grant me 3 weeks' time? Now yes, Lord. The
There is
land
a
which-
direction for consideration, page 16.
We have actually issued an endorsement, Lord.
Where is
the? No, Lord, it's on 20th of March 24. I'll file it with my.
Just give that.
Now,
endorsement.
what has happened, my lord? The complainant's land was acquired for reconstruction of a tank, my lord, in the year 1960. And they sought for allotment of an alternative land in lieu of cash compensation. Now, an extent of 150 acres of forest land was identified, and the government decided to release it in their favor, my lord. And it was also handed over to the revenue department. But it so happened that the forest department continues to be in possession of that land, my lord. And they have fenced, and it's a full-fledged forest today. So therefore, my lord, that allotment of that 150 acres of land which the complainants are seeking, that may not be possible to allot to them, my lord, today, keeping that section 2 of the Forest Conservation Act also comes in the way. Now, what is required to be done at the same time is to identify an other
Some other
extent,
land
some
and-
other land, my lord. So I have also initiated these talks with the principal secretary, my lord. Some time may be given to pursue so that some justice can also be done to the complainant, my lord.
Direction is consideration of the representation.
with
They are going one step further.
No,
They say we are going to give the land itself.
Karan, my lord, one submission. My lord, the 150 acre of land which is identified for disbursement of the land for the land losers. In lieu of that, forest department is given 272 acres of the land. Because 150 acres of land is taken back to revenue department. Possession is handed over. Revenue department has taken the possession. In order to compensate the forest department, 272 acres of the land has been given to forest department. That is also in the
Have they
possession of-
accepted it?
Yes, it is admitted, please.
My lord, what happened?
No, two things are there.
Yes.
Simple things we
Yes.
understand. You had taken particular land back, given it to the revenue department. In lieu of this, you have given more land to the forest department. Has it accepted your gift?
No, Lord, I need to take instructions on that part, my lord. But today, insofar as the land which they are seeking for it, the record shows that it is a forest land.
Because
And
of
it's a
latest
full-fledged flora and fauna
It
there.
has to be denotified, my lords.
No, it's not simple.
Correct, my lord. I agree, man. I agree, man.
Therefore, they are doing something.
Please, man.
Instead of rejecting.
Yes, yes.
Which they
I
could have
understand,
done.
man. Yes.
Wait for some.
Two more matters are pending. my
Connected
lords.
matters.
Yes, I'll give the numbers, man. Kindly tag it along with these matters.
Your lordship kindly has it in the month of June, my lord. By then, I'll also initiate the talks and see what can be done.
First week of July, we can have, in the meanwhile,
Yes,
do
ma'am.
something.
Definitely.
Because they have given land.
Definitely,
For
ma'am.
the
It-
reservoir.
There's no doubt that justice
Fourth
needs to be done.
Please, man.
Grateful.
I'll give the numbers, man.
So to be listed,
Listed along with this.
to be listed, number will be.
Seal number 16,
Lordship, but tenant, that's the direction of the honorable court is to reply to annexure J series by accused number 1, my lord.
Then represented. What is it?
Have you considered the representation?
Payment of
For
complaint.
respondent 2 minutes. We had received the notice yesterday, so we filed Vakal today
No,
morning.
I'm filing complaints, my lord. So far as the direction issued to the Tahsildar is concerned, my lord, it has been complied with. The rest of the direction is against the KIDB. I have to consider.
Because I humbly request for 2 weeks' time so that I can get apt instructions and file a reply to the same.
Not, for a short accommodation to go through the complaint.
What Tehsildar has done?
Now, Tahsildar considered, my lord, the annexure J2 to J4 representations and forwarded it to the KIDB.
So then,
Not
after,
sorry, go
by
to
the
the-
time it will be complied with.
Okay,
20.
now the matter has gone there, na? All my information is furnished by the revenue department to the KIDB. They have to process it. So we'll call it after vacation. In the meanwhile, he will say what they have done.
Please, please.
26th, where you comply with whatever your part is required. 26th.
Please.
26.5.
Number 17. Chidananda P.
Not right, Jim.
With your lordship's kind leave.
Yes.
My lords, may please permit me to state that the acquisition provisions relating to land acquisition under the KID Act are envisaged under Chapter 7 of the KID Act, where under from Section 28(1) to 28(8), land is systematically acquired after the modalities of issuance of notice, etc. And compensation is dealt under Section 29. I only request my lords to please have Section 29 of the KID Act.
What's the submission?
Lords, the submission is that in terms of Section 29, if there can be a consent agreement, the compensation will have to be disbursed in terms of that consent agreement. Failing which,
It becomes a general award.
Under Section 29(3), the SLAO or the acquiring authority, a delegate of the acquiring authority, there the language used is the state, has to pass an award in a manner known to law, my lords. Now, earlier there used to be the Land Acquisition Act used to be read as a part of the KID Act in terms of Section 30, and as late as 2022, we have amended it and included certain provisions of the new act.
Schedule.
No, my lords, that would be through the board resolution. But now there is a proper amendment, my lords, the latest 2022. We have incorporated certain sections from the new Land Acquisition Act which relate to making of award, etc., etc. However, rehabilitation and resettlement are not taken there. Now, my lords, here in this case, what has happened is a certain stretch of lands of the respondent herein gets acquired by under the KID Act. Now, my lords, under Section 29(2), a price advisory committee is constituted which fixes a price for consent award. They, my lords, they are not ready to accept the consent. So they approach this honorable court in a writ proceeding. My lords will find that writ order.
Page 280.
Page
29(2) is fixation of compensation by consent.
By consent.
It's a consent award.
Consent award. Consent award, please.
If it is not consent, then it travels to 29(3).
29(3).
That's what division bench said.
Please, that is what the statute, there is no ambiguity on that.
Number 1. Number 2, if it travels to 29(3), compensation is payable under 2013 Act, which you have incorporated by amendment.
Please.
That is the issue.
Please, no. The issue here is, my lords, what has happened is, they do not want to take under consent. They approach this honorable court in a writ proceedings, in an earlier round of writ petition, not what which is impugned herein. My lords will find it at page number 280. In terms of that, my lords.
Your appeal book.
Please, my lords. Appeal book. Page number 280, Annexure J. Volume 2, my lords. I'll put it in a nutshell, my lords. There is nothing much to traverse. The learned single judge says, yes, the 29(2) is not to be gone into. That portion of 29(2) as regards these people is quashed. You pass an award under 29(3). Now, my lords, what the SLAO does, also interestingly, there, my lords, there is a representation given by them. And say, consider that representation also is what they say. Now, my lords, having considered that representation, where they are saying that there is an unscientific method adopted in coming to that consent award price, the SLAO issues an endorsement saying that there is nothing unscientific about it. If you want, you can receive under Section 29(2) a consent award amount, and this is the amount is what they say. That endorsement is at Annexure K. My lords are having page number 280, my lords.
Lordship, kindly take to 285 page number.
I will complete my submission.
218.
280.
280.
280 would be
Volume 2.
Volume 2 would be the first round of litigation. They come before this honorable court, the learned single judge of this honorable court. The order stands at 284, my lords, operative portion. Therefore, petition stands disposed of quashing Annexure K insofar as subject property. Annexure K is that consent award proceedings. insofar as subject property and special land acquisition officer, third respondent, is called upon to consider the petitioner's representation dated so and so while determining compensation under 29(3). 29(3), which
So
means
not
he's
consent.
not consent. Now, my lords, annexure K to the writ petition may kindly be seen.
Page number?
On page
K285. It is at Kannada, my lords. The translated version kicks in at 288. Therein, my lords, having traversed through the whole thing, the SLAO says you are free to accept under consent this amount, and he leaves it at it. This is the consideration of the representation of the petitioner. Pursuant to this, my lords, at annexure M, my lords may have annexure M. There is an endorsement issued which is much after. My lords may please note the dates. The dates are relevant. The annexure K is issued on 26/12/2022. And about 9 months later, an endorsement is issued to him, calling upon him that yes, if you want, you can take under consent. If not, if you want to take under consent, here are the consent agreement and all that. You will have to get these documents, 100 rupees bond sheet and all that. At this juncture, my lords, having received this notice, the respondent herein approaches afresh before this honorable court. And he takes up a contention, my lords, that annexure K itself is an award under 29(3).
Annexure K.
Annexure K, which is an endorsement. My lords, the award as such is not defined under even the old Land Acquisition Act or for that matter, the new Land Acquisition Act. But my lords, the latest 2023 judgment of the Honorable Supreme Court says award at best should be perceived as an offer in the eye of law. That is a settled position of law. It is there, my lords. I'll provide that. Now, my lords, for an offer to be there, there is a mechanism which is stipulated by a curtain of judgments. Either you go through the sales statistics method or a capitalization method. To go through the sales statistics method, they will have to traverse what are the current market value, etc., etc. And then, my lords, they should pass a proper award. In this case, the award only is not passed. The respondent herein approaches the learned single judge, takes up a stand that an endorsement issued, asking him to receive consent award if he wants as an award, and secures an order by misleading the learned single judge that he is entitled to receive the consent amount without signing the indemnity agreement or the agreement not to go in further appeal.
Where is that so-called award according to him and your annexure?
Well, that award is
L page.
Annexure K.
K.
Page number 285. It is in Kannada, my lords.
285.
285. Volume 2.
M itself is at 314.
Lords, M is after this endorsement is issued, he is called upon to come and submit the documents and enter into. Okay. But in compliance with the earlier order of the learned single judge, he passes this endorsement. Now, this endorsement I'll read, my lords. The Melkanda Ramnagar Jille Raman Adesha is at 287, my lords have.
87. It's Kannada. Go to English.
Please. 294, my lords. Wherefore, the value fixed by the board for the lands. Board is, my lords, the consent award is fixed by the board, or rather approved by the board. There is a price advisory committee which fixes it.
294.
294. The operative portion is at the bottom of the page, foot of the page, my lords. Wherefore, the value fixed by the board for land so and so and so, situated in so and so village of Ramnagar Taluk, Ramnagar district during 376 meeting is pertinent, and since already compensation is being distributed, the applicants are also instructed to receive compensation at fixed price, and accordingly, in consideration of representation, the case has been disposed of.
This part takes the character of award.
No, I would, my lord, state that is where our contention was. An award should necessarily go and have, whether it is an award or no is the only question to be decided.
That's what. We feel it's an offer. Award is an offer. 63 Supreme Court.
My lord,
award is an offer.
Please, my lord.
You cannot go below that.
Please.
It is for him to accept or not to accept.
Please.
Not accepted, he goes to 18.
Please.
Almost similar scale. Therefore, the offer can be construed from a series of documents.
My lords, this is what our submission is, that this is an endorsement to the representation they have given. That
What you said in that?
In
Just
that
read.
I say, after having traversed that, the board has taken into consideration, because my lords, his representation says there has been an unscientific method in determining the 29-2 compensation.
Leave all that. Come to page 294 bottom. It is an order. You may call it an order, firman, whatever. Question is, with this text amounts to award or not? You say it is not. He says it does.
Please.
Read it now.
Wherefore, the value fixed by the board is the beneficiary of the acquisition. The board cannot determine the value. My lord.
Read, don't
Value
interpret.
fixed by the board for land serving so and so of Kanchanaguranahalli village, Bidadi Hobli, Ramanagara Taluk, Ramanagara district during its 376th meeting.
Read.
Dated so and so is pertinent, and since already compensation is being distributed, the applicants are also instructed to receive compensation at fixed price. Fixed price, and accordingly in consideration of representation dated so and so and so. The representation is to be seen. That representation says there is an unscientific method adopted in coming to the consent compensation mechanism. And my lords,
You asked him to accept the compensation.
consent compensation. That is why this has to be read in tandem with my annexure M, my lords. After this, I issue him annexure M saying that please come, give me your consent, give me your indemnity bond, give me your agreement, and I will execute that. There is no difficulty. If he wants any award, my lords will pass an award.
Please. Consent, the acquisition by consent contemplated under 29(2) is the subject matter of a plethora of judgments of this court.
Please.
Few of them I have authored.
Please.
Admittedly, it's not a case that fits into 29(2).
Please.
You admitted that.
Please, my lord, because he
Traveled to 29(3). Question is whether it is an acquisition by agreement or not is not the question. Because it is admitted position, it is not under 29(2). Then it travels to 29(3). In 29(3), what you say is, you accept this compensation, not in the guise of 29(2), in the light of committee's fixation of certain price values.
That committee is consent amount. Now he is trying to take consent amount, my lords. Now he is trying to take, under guise of this protection, consent amount without any fetters of not filing an appeal, along with statutory benefit. This amount under
You have
370.
said accept that money. Kindly read your English.
That is under
translation.
29(2), and that is what it is to be read. That is why, my lords, I would say what requires to be interpreted by this honorable court is the earlier order of the learned single judge in an earlier round of litigation. The earlier order says there is one representation which says that there is an unscientific method. I will rephrase once again. My lords, may please permit me.
You are not differentiating between acquisition by agreement, payment of compensation under 29(3) when it is acquisition. It's a compulsive acquisition.
Compulsive. Please.
To use terminology of V.G. Ramachandran. It's a compulsive acquisition.
Please.
Question is not about the nature of acquisition at all. Question is about the payment of compensation.
Please.
Whether it is under agreement or under compulsive, you have to pay compensation.
I have to, my lords.
You have to, number one. If it is 29(2), it's very difficult, no difficulty at all, because addendum of the parties will govern the issue. 29(3), you have told him you accept this compensation because it is appropriate compensation amount. ಮೌಲ್ಯ ಸಮಂಜಸವಾಗಿದ್ದು ಈಗಲೇ ಪರಿಹಾರವನ್ನು ವಿತರಿಸಲಾಗಿರುವುದರಿಂದ ಈ ಅರ್ಜಿದಾರರಿಗೆ ಸಹ ನಿಗದಿಪಡಿಸಿದ ದರದಲ್ಲಿ ಭೂ ಪರಿಹಾರವನ್ನು ಪಡೆಯಲು ಸೂಚಿಸಿ ದಿನಾಂಕ 17/3/22 ನೀಡಿರುವ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ಪ್ರಕರಣವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದೆ.
I would only say to
We
that.
want to know what is meant by this. You offered money to him.
Lords, I will clarify.
No, we want to know.
According
By
to
simple
us,
language,
our officials, even before the learned single judge, my lords, I'll point it out in the impugned order that we took a stand that this was an offer to accept under consent. This endorsement.
Offer to?
Accept under consent.
No.
Because
It is not consent acquisition at all.
my lords, because the board resolution pertains to the amount fixed. Now what is happening, my lords, I'll only clarify. My lords, I'll only clarify. My lords, may please permit me. Now at this juncture, they are trying to receive the consent amount, which is about 10 times the market value.
We do not know. You have said receive this money.
The endorsement, that is why it is an endorsement. The award is now drafted. I'll produce the award.
It is Adesha.
Well, lords, I'll produce a copy of an award, which is actually not passed as such, but it is drafted and kept up. There, the entire sales statistics method is taken into consideration and the appropriate market value is determined. Even otherwise, my lords, I'll only try to impress upon on the last point. Can he pass it, divorce the law? Once you have amended and taken the new act, there is a statutory requirement to pass as per section 23.
Why did you say this?
My lords, this is to be, that is why the question of interpretation has come, that this endorsement.
We interpret it, but not in a way you want us to.
My lords, now the problem is, I'll only explain the financial loss to the exchequer. Because there is a wrong endorsement issue. I'll only press upon this.
Have you taken any action to, was it your contention? This is wrongly issued. It's your argument. By argument, you can't say. It's
Lords, I said it is section, it's a consent under section 29(2) in the impugned order. Now I'll undertake to take an action against him, my lords.
That is not going to improve the things.
Because, my lords, it is very, very vaguely configured.
You did it. A person who has vaguely done things cannot say, you cannot complain against himself that what I have done is vaguely.
Lords, now the problem would be that we have lost to the financial exchequer. He would unjustly enrich
will pass
himself.
on. After all, you will not retain that property. You will give the property to the persons who want to have it. Get that money. It's not that you are paying it from your pocket. You fix the prices when you allot the sites.
Now the problem is, this is one portion of the land. It's a 1,000-acre acquisition. The same will apply to the entire acquisition, my lords.
We do not know.
It will open a floodgates.
We will say so far as the complaint is concerned.
No, my lords, I would only say, now, my lords, the consent amount is usually 10 times the market value.
We all don't know all that. You have said that, see, in Indo-Afghan agencies, the apex court said, Fatla, it said, if you give an impression to a particular citizen, that impression will bind you. We followed Justice Felix Frankfurter's judgment of US Supreme Court. Said, if you have structured your stand in particular way, and he acts upon that, he made a representation, you pass that order on the basis of the representation, that binds you.
Well, that representation was an unscientific method. My lords, see the representation. The representation was not from him to, my lords, please permit me, because of the simple reason that the consent amount is usually 10 times the compensation.
It may be 100 times. You said, take this money.
I said, take it under consent, my lords.
We do.
Because he had given a representation in that, my lords,
said it was unscientifically fixed, etc.
Please, my lords.
That representation. But you have considered the representation and passed the order.
My lords, I have said it is now considered, it is not unscientific, it is in a manner known to law. Now I have an award. I haven't, unfortunately, I'm restrained because of the court order, I cannot.
In earlier petition, the consent award was set aside.
Set aside.
And 29(3) you proceeded, you passed the order, it became general award. Then everything will follow thereafter, including right to reference.
It has been consciously passed by
Nothing
they have referred to the
nothing complicated.
order passed by this honorable court. They have taken that it's been passed under 29(3) and they have passed it.
Nothing is complicated as you are trying to make it simple.
No, my lords, only this.
The argument of loss is misconceived because you pass it on to the intending allottees.
Because that will open a floodgate, my lords, the entire 1,000-acre of acquisition.
Bridges are always like that.
My lords, I have only two requests, my lords. My lords may permit me to make two requests. One, my arguments may be noted that this is a 29.
We will consider every argument. Have you ever seen that?
No,
I'm
only requesting. And also, my lords, my submission that this officer has wrongly passed this order.
It is not open to you to say your officer has passed a wrong order. Read 69 Supreme Court. 69, because you have not taken any action against, nor you have not taken any action to recall that order. It's an order, and he acts not as your officer, but acts as a persona designate under that provision.
Lords,
Can't say.
one
My
final,
officer has
one
erred.
final argument, only to impress upon a feeble submission. This order has to be read in tandem with Annexure M, where I call upon him to take the consent. It is not to be read in isolation, is my submission.
You'll consider.
That is when he comes and challenges it before the court, saying that I don't want it under consent. I'll perceive that to be the general law. Lords, it may be only restricted to this petitioner alone. If not, it will open a floodgates for me. It will have a financial implication. The whole industrial area of 1,000 acres will practically be shunted because of one officer doing something wrong there.
Reasons to follow. Order is confined to the writ petitioner.
And should not be treated as a precedent.
We can't say that. It's for the other court before whom you cite that judgment. That will decide whether our judgment has got a precedential value or not. We can't say our judgment does not have precedential value. It's always precedential value is decided by the court before whom our judgment is cited. We can't say.
At least an observation that it is restricted to the parties alone.
That will have.
Please. Deeply obliged.
Obliged.
So for the compliance, how much time? Because that we will give 2 months, 8 weeks. We will give 8 weeks. Complaint disposal.
3 months. 3 months. 3 months.
3 months.
3 months. 3 months. Deeply obliged.
Number 18. SV, but
My lords, I have filed
For
power
repetition.
for respondent, accused number 2, my lords. For accused number 2, I filed my power this morning.
Contempt.
What was the direction?
Please, my lords.
Direction, my lord, your lordship, I get it at page number 25. Starts at page number 25, para 14. In that view of the matter, the petitioner is entitled for compensation payable as determined in the award at annexure F. More particularly, as per paragraph number 10 of the said award, proportionate to the extent of the land which the petitioner is entitled to. At this stage, the learned counsel for the respondent authority submit that an opportunity be reserved to the respondent authority to take steps as contemplated in section 3, subsection 5 of section 3G of the National Highways Act 1956. It is up to the respondent authority to take the steps in accordance.
SLAO shall pay the balance amount in terms of award produced at annexure F.
Yes,
Page
my lord.
26, last 2 lines.
That is, as per
Where the
the,
payment?
subsequently, I have been asked to make a representation also. I have given the representation, your lordship will get it at page number 27. Enclosing the.
My lords, I may just be permitted to hand over a copy of a memo, court office of.
Documents.
No, my lords, what happens in this case is under section 3G5, the award, there were 2 supplementary, one award was passed and the supplementary award was passed in respect to the same acquisition by the same authority, that is the SLAO. But however, now the project implementation unit.
Where is your objection?
Please, my lord, I filed my power this morning, my lords. I may just be permitted to file one memo. I shall file my detailed statement.
Well, no, there are no 2 stages that way in proceedings. You have to
submission-
file your statement. I have complied with. I have not complied.
Please, my lords, please,
Reasons
my
for non-compliance is
The
this.
reason for
That
which-
you have to say, not oral argument.
No,
You have to
it's-
state in writing.
Yeah,
Read the
I've already have stated it in the kind of a detailed memo, my lords. My submission is only this much.
It cannot be my memo. Affidavit has to be filed reporting compliance.
Please,
That is the
I shall,
requirement of it.
just a week's time may kindly be granted. My objections are ready. But however, the person who needs to sign the affidavit, the officer concerned, is not in town. So for the non-receipt of the affidavit, I'm unable to file my statement of objections.
Affidavit. Let him file the affidavit.
After vacation.
After vacation.
Prior to that, my lord.
After-
Reason being
10,
2021, my lord, the
All
award.
right, nothing will happen. After
11th
vacation.
June.
Number 19. Issue Baba Mishra.
Complainant, my lord.
Respondent, my lord. Yes, my lord, we have filed a review petition, my lord.
Review petition is pending now.
Pending, moreover, my lord, there is no direction by this court, which is with respect to the aluminum, my lord, they have got the alternate remedy of filing the execution petition, my lord.
My lords, may kindly peruse the order at page number 16, Annexure A.
This is in MFA.
Please,
Please, my lord.
We should execute it.
Yes.
Please, my lord, I have a judgment which says contempt and execution are both remedies available to me. I may pass on that judgment as well with Honorable Supreme Court. Paragraph number 20 of the citation.
But review application
is pending, my lord.
The Supreme Court had dismissed their SLP, my lord.
SLP is also dismissed.
Dismissed,
Yes,
my
my
lord.
lord.
Any
Annexure B.
liberty was given to you to file review?
Yeah, please, my lord.
The order may be perused, my lord. The SLP order at page number 18.
But if SLP is dismissed, review is maintainable. Mr. Raghavan, review is maintainable.
Yes, then when review is going to be posted?
My lord, this is already filed, my lord. Review petition 95 of 2024, my lord.
But some amount you have to make payment, that you can keep on saying that it's a question of family, matrimonial matter it is.
My lord, since I did not been represented by the council, my lord, in MFA, my lord, it was passed, my lord, thereof, my lord. At page number 9, you can find it.
What is your income?
1,60,000, my lord.
Every month?
I'm a professor, my lord. In the
Professor?
In engineering college, my lord.
Which is your pay scale?
My lord, it can be in the orders, my lord, at page number 13, my lord. Line 3, my lord, 1,67,081, my lord.
That was in which year?
It was 2020, my lord.
2020?
2020, my lord.
Thereafter, twice revision has taken place in engineering colleges. What is the amount now you are drawing as salary?
Since is only income is only salary, my lord. So that, my lord.
Only salary, how much?
To ascertain by the.
Chief, such people should be arrested and
Lord, then,
taken. By judgment is affirmed by the Supreme Court. Otherwise, other day. He says his salary is 1,71,000. It must be about 2 lakhs. At least in 2 judgments we have already had. Arrest and detention is the only way to execute these people.
My lord.
We are just thinking whether your client should be arrested and detained in some room in the High Court building.
He is a professor, my lord.
Therefore, he should be. If he were to be laborer, some Kalegoda, Malegoda working in the land, we'd have understood. He is a professor. He does not want to pay. You lost the battle even at the level of the highest court of the country and not third party, your wife, your children.
Please, my lord. But now he is unable to pay this amount, my lord, at one time or in a very difficulty, my lord.
So review will not detain us from.
Detain us from this, because he has lost a case in SLP also. He has money to fight the battle up to the apex court. Of course, it is his right, but it is his duty to maintain the wife and children.
Review is only relying. So your
25%, my lord, but
right now, what do you want? Whether you want, you are willing us to pass the order, or you are ready to deposit the amount? There is no other third alternative.
Not entire, my lord, 25%, my lord, within 4 weeks.
How much?
25% of.
No.
My lord. It will be difficulty for him to arrange the money, my lord.
Hello, all people, married people have difficulties.
My lord, if I may
No
make
ground.
a submission. If I may make a
It is
submission, my lord. in
75
fact-
lakhs, my lord. It is not. Yes, it's 75 lakhs, my lord. A respectable submission, my lord. At least 50%, my lord, 4 weeks, my time may be granted, my lord.
You must have your savings and BPF and GPA and all.
Lot
not-
of savings.
What
they will
not?
have. They will have lot of savings, but they will not save wife and children.
You're teaching in which subject?
Engineering professor. Professor of engineering.
So you engineer some amount for your wife also.
50%, my lord, within 4 weeks.
No, now, we won't consume much, we won't devote much time to
My
this.
lord, if I may make one submission. In fact, in the MFA, there was an order passed for maintenance. That also has not been complied by the,
What is the age of children?
please, they're 14 years of age. They're twin girls and they're studying in a school which is being, the entire education is being funded by the mother.
Should be arrested.
The 50%, my lord, within 4 weeks, my lord. A respectable submission, because it's very difficult, my lord, to arrange the money, my lord.
Always money does not come from heaven.
So you have to
But he
take,
will have difficulty in nothing. You have a fixed salary.
you have to take a loan from the bank and
Whatever you want to do it.
50%, my lord, within 4 weeks, my lord, my respectable submission.
You have troubled the wife and children enough now.
4 weeks, my lord, at least for 50%, my lord, it will be deposited. My
So we grant you.
Yes, arrested.
My lord, because since he is a professor, my lord, engineering students, exams are going on, my lord.
The complainant is wife.
Please.
When you file your affidavit of your client.
I'll file my affidavit.
Monday,
Monday,
11.
Monday, ma'am.
Monday till 11.
Monday, ma'am.
Learned counsel, Mr. So-and-so, 6 time till 8th of, 8th of May, 8th of April. To file affidavit
Please, ma'am.
of the respondent husband regarding compliance of the directions of law and a single judge contained in paragraph 22 of order dated July 23. Stating further that the complainant is ready to, sorry, the respondent is ready to comply with the directions.
50% of amount due.
By paying 50% of it is now payable under directions within 2 weeks. Full stop. In order to enable the respondent to file such an affidavit before the court. In order to enable the respondent to file the affidavit with such commitment or not before the court, time is granted up to 8th of April to be listed at 11.
Number 20, to
About the
Vijay
complaint.
Suma ready.
Lord, in this matter,
But the
to the
complaint.
accused, Lordship may call it on 16, by which time, my lord, I'll see that.
You will comply the.
Please.
He says, we'll
Please,
dispose of
please.
that matter with assurance that he will comply with this.
Please, minute.
See that if it is payable, my lord, we'll have definitely make it.
The directions in the order of law on a single judge brought under the present contempt application is only to direct the respondent BBMP to consider the representation dated 31/1/18 made by the petitioner. Post of learned advocate Mr. So and so.
2 weeks, we'll
For the
consider it.
PDA states that the directions will be completed within
2 weeks.
Within 2 weeks from today. Paragraph. This satisfies the complainant represented by learned advocate Mr. So and so, so and so. The content application are closed.
Liberty.
Disposed of.
With liberty.
Liberty, it is observed that the non-compliance of the statement made by learned counsel for the respondent shall expose the authorities to press round of contempt.
Hearing on interlocutory applications, number 21, Mr. Prakash.
Lord, I appear for the
The
complaint.
writ appeal matter, my lords. The contempt is connected along with the writ appeal, my lords. In the contempt is connected along with the writ appeal.
Make use of mic.
My lords, the contempt is connected along with the writ appeals. There are 11
Wait,
offices.
writ appeal also.
Please, my lords. I just need another day's time to comply with the office objections, my lord, in the writ appeals. Pursuant to an orders passed by your lordships on 23/1, my lords, the entire papers were given to me.
The land loser.
My lord, he is asking for an alternate site and we had rejected it, my lords, for the reason that it is in the park areas, my lord. Originally, the sites have been allotted to us, allotted by us, but my lord, subsequently we found that it is in the park area. And now, my lord, the learned single judge says that these sites being in the park areas have been directed to give alternate sites. My lords, I have challenged that order, my lords.
What's wrong with the order? You had already allotted the site wrongly, which you should not have done, because Supreme Court said those areas cannot be used as sites at all. You gave that site to him. And after realizing that such sites cannot be granted, you cancelled the allotment and you have to give another allotment. What is the wrong with the order?
The papers are voluminous, my lords. I'll take my lords to the papers. I will kindly grant it some time. I'll complete the office objections, my lords, and I'll make my submissions.
My lords, I'm for the respondent number 2 in the writ appeal, my lords. This is the second time it's coming for the compliance of the office objection.
On 23/1, my lords,
Lord,
the
three
entire
times
papers
it
were
has
given
been
to.
rejected for non-compliance deliberately, my lord.
23/1
to
order
delay.
may kindly be seen, my lords. Lordships showed indulgence to me on an application filed by me that the papers relating to this file was unavailable in the authority's office, and thereafter an application was filed on the commissioner's affidavit requesting your lordship's indulgence, and the orders were passed by your lordships to directing the office to grant me the papers. I took the papers from the file of the High Court and then complied, trying to comply with the orders. There are almost close to 300 pages in Kannada, my lords. I'm getting the translations. It's complete, my lords. I'll file my complete.
2 weeks, 2 weeks time is granted.
Please, my lords, please.
Meanwhile, my lord, this
be
application
listed
may
on
kindly be allowed
20
because
second.
the commission.
Appeal is there.
22nd
Their
will
appeal
list,
is-
22nd of this month.
Please, my lords.
So within which time we remove the vote.
We'll do it, my lords. Oblige, my lords.
You give that number, appeal number. Post it. Okay.
Already. 515. Yes. 515.
2 weeks.
Still number 22.
Appear for the petitioner's counsel in the item number 22 matter, my lord. A has been filed.
This will come here. You can see. Categories are different.
Yes.
IA is filed, my lord, by the petitioner to declare his result. He has appeared for 2 exams held in the month of November, January, and he has written the exam. Results are declared by the university. But according to the interim order, his result was withheld. Now he has to pursue, he has to go for the second year. On merits, it was argued before another bench. It was almost posted for a dictation of judgment at that time. The honorable judge was elevated as Chief Justice, therefore.
24 January 24 order.
Yes, my lord.
But that order says result shall not be announced.
Yes, my lord. Now that he has written the
But
exam.
because we cannot have repeated interim orders. So that was the
have a
intention why
course.
the
My
main
lord-
matter was
My
heard.
lord, your lordship may kindly see the situation. There was a direction to present the argument. Argument was presented. It was posted for dictation of the judgment. Due to some inconvenience, judgment was not passed. His one precious year should not go wasted, my lord. Student's life is involved.
Let's argue on merits.
Please, my lord.
Yes.
I appear for the petitioner in the connected matter.
Yes.
This matter and that matter is entirely different, my
No,
lord.
my lord, the same modus operandi that is why we have clubbed them together. In the previous academic year, what modus operandi they adopted was adopted again. That is why we got both of them clubbed together so that it becomes apparent that what is the technique used to.
And this application is also filed by the
It is also by
affidavit
advocate.
the advocate, not by the student. The advocate
We'll
can
hear
file-
the main matter. No, you cannot file that. Affidavit under rules of practice. Anyway, we are taking up the main matter. Please.
Please, my lord.
Start.
My request.
Let us see.
Lord, it may be, may I
Because, you say that it's urgent matter.
Yes,
Therefore, we
madam.
want to hear and
Yes,
dispose of. We cannot run the courses by interim orders.
Your lordship may kindly see ink page 54, my lord, of my writ petition.
Give some foundational facts.
Foundational facts, my lord. The last date for, I am filing, I may permit it to file the synopsis. Facts of the case. (29/12/22) was the last date for filing of the, for the acceptation of the admission, my lord. On that particular day at 5 PM, the name of the petitioner was taken by the fifth respondent college and he has completed all the formality. However, while recording the name, my lord, a wrong name was recorded, my lord. Page number 23 may kindly be seen. Immediately the college page number 31 may kindly be seen, my lord. The name entered by the fifth respondent college was Manas Mitras Uppu. Immediately, the college has sent a mail.
You said which page we should look into?
31, my lord.
Manas Mitras.
Manas Mitras Uppu. He did not approach the college for admission, but somehow by mistake, that name was entered by the college. The application of the present petitioner at ink page 26, on the same date, there are 150 entries, page 26. Amit Dattatreya Kodse. He has submitted the application on 29/12/22.
No, what you want to show to us by drawing our attention to page 31?
Page 31, the college made a wrong entry of writing Manas Mitras Uppu instead of Amit Dattatreya Kodse. The college realized that they have made a mistake. Same date, they have written a letter on 29th. Ink page 32 may kindly be seen. To the Director of Medical Education, Bangalore, we hereby submit that while uploading the list of candidates admitted for the MBBS program for the academic year 22-23, there was a mistake which we have noticed now in entering the name of Manas Mitra Suppus. However, the same was purely by an oversight and clerical mistake. We now request you to replace the above candidate's name with the actual admission for the 4.5 years MBBS program for academic year 2022-23 in the name of Mr. Kodse Amit Dattatreya. Hope you would consider our request favorably and
Okay,
replace the
understood.
name with
How it is affecting you?
no, my lord. Now
Yes.
I am the petitioner. My name, even though it has gone to the university, university has and it has been recorded at item number 1, page number 68, my lord.
Yes.
Page number 68, item number 98 and 99.
So same name is repeated.
Same name, Asad Muhammad Nawaz has been repeated. Whereas my name has been not been included in the list of KAT, in the KEA. Your lordship may kindly see annexure M issued by the NMC. Page number 54. Item number 150.
54.
54, my lord. Item number 150 is my name, Kodse Amit Dattatreya. KEA should have forwarded this name to Rajiv Gandhi University, and Rajiv Gandhi University should have issued me the hall ticket for the exam. We have informed all the authorities in time.
You are
The- College has admitted in their letter that the wrong entry of the name, the KEA ought to have corrected the entry and send it to Rajiv Gandhi University, but they have not sent it.
Page 54 is merit list.
In
Page-
NMC list, my lord.
What is that NMC list?
In National Medical Council.
So what is the basis of your submission that your name should have been reflected at the place where two names are repeated?
Two names
One
are-
name is repeated twice.
They say that I came late,
No,
not on 29th.
Do you figure on merits?
On merits, my lord, on 29th was the last date. I have paid the fee and I have
No,
entered
no,
my.
on merits, what are your points which you had
On
scored?
on merits, my lord,
Yes,
on merit.
marks obtained.
KEA has considered that I have come in time and my admission is recorded.
What is
But-
what is the scorecard? What's your percentage?
Percentage. Page 23, my lord.
We did not ask you page number, we asked percentage.
Percentage total mark that has been obtained by him is in physics 93, chemistry
281.
94, biology 94.
281 out of 300.
300. 281 out of 300.
So therefore you will have to demonstrate that the person who figured twice.
Yes, my lord.
At page, which page? 50?
Yes, my lord.
58,
Had less marks.
Yes,
68.
my lord.
You are entitled to get your name entered in this place. On the
No,
video.
no.
That you have to demonstrate. That's my-
out of 150 names.
You are trying to suggest that at page 68, Muhammad Nawaz Najma
Yes, my lord.
is repeated,
Repeated,
a repeated name of single student.
single student,
And you are trying to submit that your name instead should have been figured there.
figured there.
So you have to compare your merit with this Nazma.
Yes, my lord. That is not denied by the KEA. They are not denying it. It has gone in time.
Who
In the-
appears for KE?
Mr. Ramesh appears.
I find the detailed statement, my lord. But this petitioner, my lord, who he did not succeed in first three rounds of counseling. Thereafter, my lord, a short list will be made with regard to, my lord, the students list who have not got any seat through, my lord, the KE. So that will be, my lord, in 1:10 it has to be prepared because of the Supreme Court judge.
Was he in mop-up round?
Yes. I mean, he didn't even get in the mop-up.
Even in that,
No,
he did
no.
not.
First three rounds, the first, second and mop-up, he did not get any seat. Then who are students who are registered with KEA and 1:10 list will be drawn and it will be sent to the college portals. And only from that list, my lord, they have to admit the students.
He was not in the list at all.
He was not in the list. In the 1:10 list, he was there, but he did not go within time.
In time, he did not
In time, he
present
did not
himself
go.
there.
Yes, the college has uploaded the list of students, 150 is the, my lord, the.
On what date, what time they uploaded the list?
My lord, this, Annexure R2 I have produced, my lord. One second, I'll see the date. Yeah.
Farah.
Yeah.
My lords, I've produced memo for production of document on 24/1, as per which, my lords, on 29th December 2022 was the last date of admission.
29/12/2022 was the last date.
Date of admission. At 6:05 PM, the college has sent an email.
The 22 up to what period it is? What time?
11:59.
11:59.
11:59 PM. Please. So college has sent.
That is midnight.
Please,
It works that way. 80. Till midnight they work like.
Normally by close of
Close of
working
the.
hours.
Online, you are.
Online.
It's online.
By
Because
close
the
of-
last day, my lord, normally they keep it open.
The college sent the list to you?
My lords, at 6:05 PM, the college has sent an email, my lords. It's not like by mistake, it's not typographical error. It has they've sent by typed copy of the list of students. In that, they have mentioned the name of Mr. Manas Ukku at serial number 145.
Not petitioner?
No, no.
In the list sent to you by the
150
college,
students.
it did not contain name of the petitioner. He sent it at evening 6
6 PM, page 13 of the
PM. In
What
that,
you-
it did not, his name did not figure.
In fact.
What time it figured?
My lords, and subsequently even at 6:27 PM, the KEA has sent us the list of admissions made by the college. In that also, petitioner's name is not there and Mr. Manas Ukku's name is at serial number 62
62.
in the
All
KEA
right.
list.
In which list his name figured?
My lords, it's not in the university list, it's not in the KEA list.
College list?
Not in the college list. This is the list, my lords, probably in the larger list of unallotted students. And this is admitted students of 150 students.
150 students which they have admitted within the date, my lord, they have sent to the university, they have sent to the KE.
No.
In that, my lord, petition.
No problem at all.
Page 32 is the letter by college.
Well, let's kindly see the acknowledgement down, my lords.
No, no,
It's on
page,
3:1.
page 32.
3-2.
Please, my lords,
Is the let-
32,
is
but
the
it
let-
is submitted on 3:1.
Is the letter by college?
Please, my lords.
That is on 30th December.
At on first 3:1, it is given on 3:1.
No,
Down, my lords,
29.
the seal. Dated 29, but it is submitted on 3:1.
3rd of January.
What time it reached you?
And let's, it is to the DME, my lords, not to the
They have
university.
not, they were given to Director of Medical Education.
Director of Medical Education.
And that was on 3rd of January, not on 29th of December.
So who is for college?
I'm sorry.
Who is
College, council for college?
Mr. Srikanth.
Huh?
Mr. MP Srikanth.
College sends it to the authority. That's the only standard. Yes,
Page
Katie?
30, page 31, the previous page. That is an admission order which shows Manas's name. Kindly see the date and the time there.
29/12/2022.
1648.
At 4:48,
440.
4:48 on that day, when they send this at 6 o'clock, they're confirming the admission of this candidate.
Dean's signature is.
Then whence from comes the other candidate at 6?
These are NRI seats.
So these are these are seats which virtually get converted into my seats. My seats in the form of
NRI.
with an inverted comma.
NRI is anybody's.
I will give it to whoever I want. So that is the import of this date. The significance of this date is that's why I said we left to us, we would have said that, but we kept quiet for that moment. We would have started with the older case so that the entire modus becomes slightly more clearer and this would have gone. But nonetheless, it's apparent in this case also, and that is why they are clubbed together. What has happened is 29th, they have admitted this last candidate. And then they say by 6 o'clock again, they say that we have made a mistake. But nonetheless, the name sent is the same old name. So what they say is at the end of it, there's no other route available. This is a tested route that they have found in 2 years, the previous year as well. So they say that we will use this route again. And by virtue of this, what happens is, if a seat is declared vacant before the last date, all candidates are in the know of things and may come forward and say, give it to me and I am more meritorious than him. But if it is done by this mistake route, the door is closed, there's no vacancy. So after that date, I'll admit whoever I want because nobody else will come to the court.
Then what is your explanation about the name repeating twice?
Now that's even more interesting. If a name is repeated twice, my lord, then there should be one more seat which is still vacant.
So that implies that one seat is available.
That implies that one seat. That has to be, now there's another dimension to this.
We don't know who will get the admission.
There was one more batch of petition.
One seat remained available on the day you published the list because the student was repeated twice.
Twice.
So where is that seat?
Even that's a question I have posed, my lord, also. That needs to.
The college should answer all this.
That we get an answer.
College should answer all this.
That is the reason why we.
In the list submitted to the university, the names have not repeated. In the list submitted before the university, no names are repeated.
No name is repeated.
No name is,
150 students.
Even that is fictitiously done.
That is fictitious.
Yes. Uploaded to the KE also.
No duplication at all.
Duplication.
And the list which comes to the NMC comes after 2 weeks.
But we are not concerned.
Not immediately.
This is just.
On
In this it is UG, in the other thing it is PG.
on 29/12, my lord, after college realized that they have made a mistake, they have written a letter to the concerned, and also on next day, they have sent a letter by mail at 5 o'clock. On the basis of that communication, my lord, Directorate of Medical Education on 5/1/23 has informed KEA to correct the mistake.
No,
KEA
the
has
question is,
not.
on 29/12/2022,
Please,
at 16:48,
please,
admission is already done.
Yes, my lord.
How?
No, admission was done for Amit Konse. Your lordship may kindly see page 26. His application he is the last person to come. His application number is 150.
But they are saying
Yes, my lord.
the list which college had sent to them
Yes.
did not have duplication of that Muhammad. That name was not duplicated at all.
Mithun Manas,
He is getting admission or not?
he is not getting the admission. He is
Not
not,
getting
he is not in the race. Mithun Manas name, it
He
was,
might have withdrawn. We don't know what is happening.
no, my lord.
This Manas may have withdrawn.
There is
And
150.
the college is trying to do favor to you
No, no,
at the 11th hour. and that too writing a letter to the Director of Medical Education.
This
My
is what is
applic-
called seat blocking, by getting one person to accommodate them and block it till the last moment, and then he steps out, and then the next person.
They will sell that.
No, my lord, my application appearing on. I've been appearing for the education institution for several years. As my learned friend said, it's a case of, and not in this fact, generally, my lord, because I will not appear, it's a case of seat blocking. What happens, first round counseling, second round counseling, third round counseling, mop-up round. Students don't get admission. The students are set at various stages to the colleges for admission. So first round there's vacancy, second round there's vacancy, third round there's vacancy, mop-up. That's the last mode. Supreme Court has said, even after mop-up round, there's 1:10, you can admit. In the list of students which are sent to the college, with those lists, you can.
Not outside.
Not outside those lists. The question is, my lords, they make a mistake, then after the last, by chance, sometimes what happens, they don't get before the 29th, which is the cutoff date for UG and PG, the student is not admitted, my lords. So then what they do is they take the student of the choice. I'm not talking about this case, my lords. That is where the concept of seat blocking has done, and Supreme Court has come down heavily saying that this kind of practice should not be done. I'm not going into this case because I don't want to prejudice the court's mind with regard to my learned friend. This is the general.
From subsequent year, all have to be routed through KA only.
Through
That's what they have
KA,
said.
and they have
They
to
have changed the whole concept now.
And that is why they did it online before the last date, both Rajiv Gandhi University, Medical Council and the KA. It should be online simultaneously.
He is meritorious student.
It is not.
Eligible student.
Eligible
Only
student.
eligible.
Need qualified student.
So you are not able to confirm that he is coming upon a particular place at the merit.
No, that cannot,
That
that
cannot-
cannot be, because unless there were competing students,
List contains all those people.
So
Comparative
the
merits cannot be.
Case of the petition does not travel beyond a point, saying that he was recommended.
Correct.
so the moment it goes beyond the last date, that means he is a solo admission. Dehorse merit.
My lord, there were 150 applications.
So now even if you are recommended, even if you are right, even if you are entitled to be considered for admission, you demonstrate that you are coming on merits.
No, I'm coming on merits, my lord.
No, that question will not arise.
Even that will not arise.
Will not arise because he was not in the list yet.
Your lordship may kindly see in page 54. In page 1, the merit number 992704, that is 2000 after me, item number 2 lakhs, the person is 144. I am 7,19,523. I am 150. I am 2 lakh earlier.
You were never recommended by the college. In the list which it was sent to the KEA, your name did not figure.
No, my lord.
No, he sent, his name was there. But after admission, they send the list to KEA back. In that, his name was not there.
In the second
The
intimation.
confirmed admission list, all 150, they'll upload. They'll upload to us, they upload to the university also. And also to the MMC. In that, it is not.
For the university.
The university, health university.
In the affidavit filed by the KEA,
Medical.
at page number 14, I am in serial number 13, my name is there, KEA.
Ramesh, when the list was sent to you,
Yes.
you found him meritorious?
But merit doesn't come into play at that point of time.
At what point it comes?
First 3 rounds it comes. First
Yes.
3 rounds it comes. After the stray vacancy round, my lord, we send a list in 1:10. And the procedure earlier was not, college has to admit only from out of 1:10. Whoever goes to the college, out of that, my lord,
He is not in 1:10.
he was in 1:10.
Yes.
He was in 1:10. In that list, he was there. But the admission should have been done within the last day.
That is 29/12/2022.
Yes.
That his
So,
admission was done on
He
3/1.
he had not.
3/1.
3/1. He had not gone there. at all. So, my lord, somebody that other names, my lord, it was there, the admission was given to them. After that, they changed their mind, my lord, they have admitted this.
Online admission, I qualified on 29th. I have completed paying the fees on 29th. Only thing, there was a mistake that has been considered by the examination Directorate of Medical Education in the affidavit filed by the
How
KE.
Directorate of Medical Education will figure what role he has got in this scheme?
The
DME.
The college.
Please, Mr. Ramesh, any DME has got any role to play in this process? Director of Medical
Yes, yes,
Education.
ultimately, my lord, for NMC, my lord, DME sends the whole list.
Huh?
DME sends the whole list through our portal.
But he says there is some mistake. DME says,
Your Lordship may see ink page 16, it is in Kannada, dated 5/1/23.
16.
Affidavit filed by the college. Five 1/23, it is in Kannada.
Ink page?
Page 16, my lord, annexure R6.
16.
In the affidavit filed by the college, my lord, Mr. Uday Kumar, Dean, he is the.
Now, what the DME said?
DME says, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ 22.
Where is that letter?
Letter.
College's version.
College version. No, letter only.
Of?
DM. Director of Medical Education.
To whom? It was saying what?
Yeah.
Annexure R6, my lord.
R6 of the objection statement.
Affidavit filed by the
Affidavit, yes,
college, my
filed.
lord.
That is Uday Kumar.
Uday Kumar. There, ink page 16, my lord.
They said like, you can check. This is in response to, my lord, the letter of, at page 15, college's letter. But by that time, last date is over, I cannot, my lord, meddle with the list.
If fresh
DME official has become kind-hearted. The DME official has become kind-hearted to suggest reconsideration at the request of the college.
After the cutoff date.
After the cutoff.
My lord, once I enter the college and admit myself on 29th, there is no question of delay. It is only the name is the thing that the college has sent a wrong name. They have requested to rectify it. It was the KEA who had to rectify it. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ 20 ಸಾಲಿನ MBBS ಕೋರ್ಸ್ಗಾಗಿ ಶ್ರೀನಿವಾಸ್ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನಗಳು ಮತ್ತು
Read English. It's a bench
Please,
complaint.
my
of
lord.
Honorable Chief Justice.
With regard to the letter referred to above.
No, that he sends after the cutoff date. 29/12 was the
No, my
cutoff
lord,
date.
the letter that they have stated, the DME has stated.
Where, what is the amount you have remitted to the college for by way of fees?
Nearly 1 crore, my lord.
1 crore.
Yes, ma'am.
We call it the absence of counsel is a scheme or?
No, my lord, he was in, he told me that he will come immediately.
But since half an hour, he is not here.
No, my lord, he may be in another court. He just told me that he will come. He has filed affidavit, this affidavit.
Now, what is R5 in the there?
R5
is the same as page 32.
Yes, my lord.
It is copy forwarded to R5 along with the objections.
Same letter.
College sent it. Yes, sir.
No, it is a different letter. It was letter dated 31st of December 22.
5
Page
PM.
33 is 30th of December 22. Two letters have been
Even
sent.
that is beyond the date.
No, my lord,
Even that letter is beyond the date.
only to clarify the mistakes, my lord.
No, we are thinking whether you should get back your money from the college. At least that has to happen. Otherwise, he will be put to injustice. Unless he himself is a party to all this game.
invariably there is a presumption because if it is after that last date, the person knows he is getting admission after the last date. There's a presumption to that effect.
Your lordship may
Because
kindly
there can't be
see,
one-way presumption that only the college has done it.
your lordship may kindly see.
The one who is
in-
admitted also knows he is admitted after the last date. The one who is admitting, invariably the college also knows it's after the last date. He also.
We are just thinking whether we should direct the college to pay back entire money with compensation.
No, my lord, it was paid on 29 by me. If I had paid after 29,
Question is not.
the question
paid.
does not arise. I have paid earlier and my application is dated 29/12. My name has been entered and the NMC has taken my name and I am at serial number 150. My ranking is also above 144, with the person who is qualified at 144.
May I submit one? One seat by way of restitution and one seat by way of penalty from its NRI quota. If they concede, then I think it would be justice.
Student could be.
Apart from what my lord has already said, one seat by way of restitution, because one meritorious student is deprived, so the status quo ante. But for doing all this, one seat from the NRI quota, given to the government. Over and above the normal consensual agreement in the next academic year.
Otherwise, this will go on like this only.
Yes, that is my respectful submission.
So the student will not, also not be harmed.
Otherwise, injustice will be caused to him and this kind of business will go on.
Yes.
This has to come to a halt. Otherwise, even innocents maybe. He may be innocent also.
It is not like that, my lord. Ramesh
Let the council for college come. Monday.
Monday we can have this.
Monday.
Yes. Can you give a judgment which matches with the facts of this case so that we can draw wisdom from such judgments?
In fact, my lord may recollect about 2 years back, I had mentioned about this when my lord was sitting single. And I had said that this thing occurs on the last 3 days. I'm sure my lord has a good memory and my lord will recollect that. And this is the opportunity for that, my lord. Therefore, my lord will have to take the trouble to write it.
All right.
I have got my.
Give one or two
I've
judgments.
got the written arguments ready because that was supposed to be handed over at that point
At
of
that
time.
point, we also.
We will.
We have it, no, we'll add it.
All right. Give written arguments you have given now.
My lord,
You-
both are- For both the cases, they were ready, my lord, at that time because it was concluded.
Okay.
Only the addition has to be with, I'll just.
You add that also.
Add that
On Monday you bring that.
The synopsis, both the case. KES.
We have filed our written submissions also. we have.
I'll hand it over on Monday.
That add.
KE has considered our admission. KE has noted down in their objection statement regarding.
Yes.
Only thing is KE did not forward the name to Rajiv Gandhi University.
Oh, no.
That's our case. In time. In time.
My lord, the second matter, my lord, we'll take it up on Monday again.
Yes, together. He said.
Monday, that is PG.
We will be seeking seeking an identical order in that. It is equally apparent. my lord.
In that it is equally.
By this college might be enriching itself.
Yes, they do all that, this.
In that college itself is the petition.
But then this
College is the
student may
petitioner.
not be at fault. It is also like
Can matter.
scenario. College might have.
No, so that is why I said,
Did not follow.
we would just be a little humane and say, okay, for the wrong done, no. But then just being humane will not be enough. Then we'll have to be harsh. So what I suggested is humane plus harsh. Obliged.
Okay. More or less similar matters we treated in Gulbarga, where we had imposed cost of rupees 8.75 crore fine.
Was it in,
Ayurveda
was it in,
Ayurveda College.
Give that judgment in Gulbarga.
my written argument also has financial penalty also, my lord, for that matter. I did not go on, otherwise it would sound too harsh on my part, my lord, until my lord seeks it appropriate. Since my lord has said it, it is already there in the written arguments, 3 counts of for their action, including the fact remains that you've come before the court and had the temerity to say all this to cover
Get an
up.
order.
Cover up in a court should be taken more seriously than just coming to court.
Mr. Ketty has not answered one thing, my lord. At
Yes.
item number 150, my name is there in his list. And there is repetition of 2 persons in the list. That he in the KEA list, that they have to answer.
I thought, my lord,
Something in
we
some
all agreed
cases,
that he has to
some-
answer.
Somewhere something has happened.
I
that
thought we
should
all
not be
agreed that he has
equivalent
to
this
answer
case,
why
sir.
that name, when it goes,
No, no.
there'll be one more vacancy. Then
My
what happened to
application
that?
is 150. My application number is 150. On 29th, I have entered the college. I have filed my application and I have paid the fees. So there is no question of delay at all. They have to answer how that 150 figured in their list and is it their mistake? That they should point to.
On Monday we will send.
Monday, man. Obliged.
This is number 23, Mr. Rohan Wasmat.
Here for the applicant.
Appearing to the club.
They will admit some students. Yes.
So this matter where there was a direction by the Learned Singh judge earlier round of litigation that I should be, this entire property of 33 gunta should be transferred to me. Reconveyed to me, my lord. After which they conveyed 20 guntas of land, which was left in this property. And instead of 13 guntas, they gave me 5 sites elsewhere. By which time, my lord, that writ petition became final, my lord, and the review and all the challenges came to an end. Now, BDA appears to have auctioned that 20 guntas of land in favor of, my lord, the writ petitioner, prior, my lord, to executing a sale deed in my favor.
Earlier argued?
No, my lord, it's not argued.
First time.
I've argued. Of course, it is after notice, my lord. Lordships had also granted an interim order in the earlier stage, but then they had already withdrawn the money by then. Therefore, that order became infructuous. Of course, it ultimately comes down to a short point. It may not, though, of course, the volumes look
After vacation.
a little.
Then it will take time.
There are some urgent matters.
12th of June.
Great.
Ready in notice matters, still number 24.
Please, Your Lordships. Now, this is a matter, my lord, where the rights of the children, or street children, my lord, I call it as is concerned. On 13/10/2010, my lord, this honorable court was pleased to entertain the matter, observing that this raises an important
issue, touching upon Article 21 of the Constitution. Then the government advocate was directed to assist the court in the matter. Then after 2 sittings, the court felt that they are not getting the proper assistance from the government. Then the Legal Services Authority was directed to look into the matter. There shocking developments came to the notice that the children aged, unfortunately, I had to say all these things in the open court news.
Whether that payment was made?
Please, my lords, now BBMP, last time they had asked to clarify, my lords, whether the complete payment is made.
My lords, I have oral instructions that the same payment has been done. I'm come on vocal today, my lords. I may be given some time to place it on record.
Entire payment is made now.
That's my oral instructions, ma'am.
Oh, that will record. Always these are oral instructions only. Simple question. Our order dated 21/9/2023.
Yes, my lords.
Whether that is complied with or not.
My oral instructions are yes, my lords.
They have made the payment.
And they must continue to make the payment.
That's also the society. Where they have received more.
The order of this honorable court is that they must not only make the payment, they must continue to make the payment regularly, annexure C in the rate petition.
No, we had made an order on 21/9/2023.
That's
after
up to
hitting-
that date, up to that date. What this honorable court in annexure C has said is, whenever we pay the property tax, 10% will go to the beggar cess. Out of the 10%, 10% is retained by the BBMP as administrative expenses. What the BBMP had done was, they had swallowed the entire amount. The amount meant for
10%
them.
and 10%
and
of that
also-
10%.
Yes, that the then Chief Justice, Justice K. observed that what even beggars' money you are taking, this is not permissible.
Let us see now that money.
Then the order
they say
annexed.
they have.
So annexure C is passed. What they said is, you make the payment and continue to make the payment.
Because he is saying that amount is paid. You can say in terms of order dated 21. BBMP submits that. That's one sentence. Can we record your submission that this amount payable in terms
The
of
balance amount which was
21/9/2023 has been remitted already?
Yes, my lords. The amount may be not mentioned, my lords. So the oral instructions that the balance amount which had to be paid has been paid. Because there has been some inadvertent error in the calculation, which I have to get instructions on, my lords.
Yeah.
55.65 crore plus 2 crore.
My lords, I may be granted
In
a
4
short
months.
accommodation. I'll get back to the calculations.
One more submission is.
We can have this matter of vacation.
No.
Because urgent matters or many of.
No,
the points
I'm
are
not,
there.
I'm not on that.
2020.
No, one more submission, I just said. On 23/4/2021, this honorable court felt that the facts of the case require a discussion in the conference hall of this
My lords, if
honorable
it's not
court.
paid, it will be paid, my
Accordingly,
lords.
directed the listing of the matter not in the open court, but in the conference hall. Patron in chief hall was directed.
That we can do only after vacation.
I leave it to court.
You have not filed your wakalat as yet.
No, my lords. I'll be
You
filing
appear
it
for
today.
BBMP.
Yes, my lords.
You want us to record this
Yes, my lords.
remittance payment from
Yes, my lords.
Learned Counsel for the BBMC, BBMP. Submitted before the court, when the present writ petition came up for consideration, that pursuant to order dated 21/9/23, amount of this 55.65 crore plus rupees 2 crore has been paid to this whom? Paid
The committee, my lords.
Committee.
Central.
Central Relief Committee.
Central Relief Committee.
Yes.
To the Central Relief Committee. Having recorded the statement. The
My lords, if a statement could also
petition
be,
is
if there is,
adjourned to
because of an inadvertent error, there is some calculations problems.
25th
That you
of
can
June,
say.
25th of
Great.
25th of.
Number 25, Mr. G.R. Mohan.
Hearing to the government.
This matter pertain to the development works in Dasaralli Assembly Constituency. 110 crore amount has been released now. They have to release balance 90 crore. I asked to file a memo that has been filed and is taken on record. And undertaking is given in July.
Question.
Please.
21/6. Number 26, I appear for the petitioner. My lord, may I request your lordships to be kind enough to see the prayer, my lord. On the face of it, the prayer may look as if I am seeking a modification of a contract that has been entered into.
Modification contract.
Yes, it may seem that way,
But it is
but
not.
it is not. There is something more to it that I want to point out to your lordships, my lord, because the contract is not a pure and simple contract. It is I would say, my lord, it is a statutory contract.
Statutory contract. Understood.
Therefore, my lord, and now the question that I place for your lordship's consideration would be, can a statutory contract be against the terms of a statute and a direction issued by the Honorable Supreme Court?
So you want us to modify the term of the contract?
Yes, my lord. In accordance, to make it to come in accordance with the order passed by the Honorable Supreme Court. And I give your lordship the facts, my lord. I know, my lord, on the face of it, it may seem a little strange, but it is not, my lord, that strange to law. Therefore, let me point out your lordship a few facts, my lord. My lord, matter arises, my lord, under what is called the Coal Mines Special Provisions Act of 2015. My lord, by an order passed by the Honorable Supreme Court, in Manohar Lal Sharma's case, the Honorable Supreme Court, my lord, declared all allocation of coal blocks as illegal, and everything was cancelled. Then, my lord, this Coal Mines Special Provisions Ordinance of 2014 was promulgated, which, my lord, culminated in the act called the Coal Mines Special Provisions Act of 2015, which received the assent of the Honorable President, my lord, on 21/10/2014. It is not in dispute that respondent number 2, namely the Karnataka Power Corporation, had allotment of a coal block. And therefore, my lord, by virtue of a special provision contained in this Act of 2015, under Section 11, there was what is called as a priority allotment, my lord. They are entitled to what the law termed as a novation. That is, in place of the old contract, a new contract can be entered into. That, my lord, your lordship will get in Section 11. May I point out your lordships, my lord? Section 11 of that act, which your lordships will find at page 226 of the memo for production of documents, my lord. If your lordships permit me, and just for convenience, I'm giving it to your lordships.
Mr. Raghavan, where is that 18.1 page?
28.1, my lord. 28.1, your lordship gets it.
18 or 28? What?
Yes, my lord. The offending
220, page 220.
220. I'm grateful to my lord. My lord, it is page 220, my lord.
Basic excavation.
Yes, my lord. Now, what happened, my lord, was there was an expert committee appointed. My lord, there was a dispute. All this, my lord, ultimately contract Section 11 was granted, my lord. All that is over. Then, my lord, the question arose: what should be the base price so far as coal is concerned? In order, that matter was pending in Supreme Court. Supreme Court, my lord, appointed an expert committee. Expert committee, my lord, gave its report on 8/2/2017. The expert committee itself provided for escalations on a quarterly basis from 2017. Now, this contract was entered into on, my lord, 19th of March 2021. Enormous delay on account, my lord, if I may say so, and it is apparent from the reading of the contract itself.
The Supreme Court judgment which says modification, etc.
My lord, I'm sorry, my lord.
The Supreme Court
No,
judgment.
no, Supreme Court didn't say about modification. Supreme Court, my lord, accepted the expert committee's report.
Committee recommended for a modification.
No, my lord, committee did not recommend. Committee provided for a base price and provided for an escalation with effect from 2017 quarterly basis. Now what happened, my lord, on account of, if I may use the expression, paper pushing, the KPCL, my lord, did not enter into a contract till 2021. And now I am saying, look, give me the increased base price as provided by the expert committee which was appointed by the Supreme Court, and KPCL filed an affidavit before the Honorable Supreme Court when I was saying we are accepting the expert committee's recommendations.
Where is that?
My lord, that your lordship gets, my lord, at page 64.
Page number?
64. 64. May I read, my lord, paragraph 3 of the affidavit that was filed before the Honorable Supreme Court by KPCL. I submit that the board of KPCL had taken a view that tenders must be called arrive at a competitive price for the contract pertaining to mining development operations, and has accordingly called for tenders. The same had been quashed by the Honorable High Court. Before this Honorable Court, KPCL and State of Karnataka had sought for tenders as a mode of arriving at a competitive price. After considering of both the parties, the Honorable Court was pleased to pass an order on 2nd of January 2017 as under. Learned Counsel for Karnataka Power Corporation, State of Karnataka say that they would like to discover the best price. So that was the submission made before the Honorable Supreme Court. Learned Counsel for MTA has no objection if the best price is discovered and his client might match that price. Learned Counsel, MTA is the petitioner before your lordships. Learned Counsel for KPCL and State of Karnataka request 6 weeks time to discover the best price. We expect that an expert committee will be set up for doing the needful. This would be done without prejudice. In terms of the said order, subcommittee of the board of KPCL held a meeting on 7th of January 2017, which constituted an independent expert committee comprising of Shri so-and-so, so-and-so, so-and-so.
It is not touch and go matter.
Requires deeper consideration.
It requires consideration, Marat. That's all. I mean, that on first blush, Marat, I thought, how can a writ like this be maintainable? But now, Marat, the law also has moved far from the traditional concept that in contractual matters, a writ will not be entertained. 2023, my lord, Honorable Supreme Court has even said Radhakrishna Agarwal's judgment is of doubtful validity. I understand, Marat. I told my learned friends also in this time to have a matter like this heard by your lord.
But when we read the prayer, that was the impression
Yes,
which
Marat.
we had.
Yes, Marat. Yes, Marat. Yes, Marat. That is true, Marat. First impression is that.
First and last one.
First and last.
Great.
Which date?
Whichever date you want to give.
Whichever date.
After 6th of June, Marat.
After 6th of June. 13th June.
Please.
Yes, great.
27 to 32 are urgent. Seal number 33, Mr. Ashok B. Patil.
After the contempt petition is filed, I filed an application for production of a document. And thus the registry has raised an objection with regard to the provision under which it is filed. Page number 1 of my application. Application under section 482 CRPC, read with rule 5 of the High Court of Karnataka Contempt of Court Rule Proceedings rules.
To remove.
That's
Objections are not sustainable.
That's my submission because under the rules, CRPC is
Office objection dispensed. Subject to further exam.
Great.
Notice has not gone.
Yes, notice is not gone. Ma'am.
For the present, subject to further.
Notice.
Notice
Right.
available on 24th of June.
Great.
Number 34, Mr. Narendra S. For the petitioners in this case, Milo.
Non-filing of reply. Reply is not filed.
Service is not done.
In respect of R3, Milord, await service,
It has not
Milord.
done on A3.
This matter, my lord, may I request one? This is a case where my lord Hakkupatra has to, there is a direction that Hakkupatra has to be done. Lordship may give me 2 weeks, my lord, I just find out and I'll file.
No,
my-
why service is not reported? Why not accomplished? He's the, not private party, he's a joint commissioner. On him also, police cannot give the service. Contempt matter.
Yes.
Oh, why police says that report, the service cannot be effected?
I'll seek instruction. It cannot be done because
What is this? What kind of police we have?
I seek instruction.
My lord permits, my lord, I'll appear, but I'll keep him present also, my lord.
So that's one thing, but where court sends,
Yes,
first court sends notice through police and the police will come and say, as if some thief has run away and therefore we cannot do. He's joint commissioner.
Yeah, cannot be.
No, it is only report is not submitted.
Report.
On furnishing of a served report,
Yes, that they have to submit to the court.
they have to come and present for the court. I'll seek.
You appear for all three,
I'll appear for both.
2 and 3.
2 and 3.
Yes, Sanjeev appears for 2 and 3.
Rest will affect the service.
No, he's appearing.
He accepts for the.
I
Yeah,
appear
sir.
for 2 and 3.
3.
Learned.
One
advisors and
AGA
accept
is for
service
one.
of
Yes,
Notice on behalf of this one, 2 and
already issued on 12
then to be listed on 13th of June.
Yes.
Number 35.
That I appear for the complainants.
Yes.
I'm appearing for accused number 1 to 5, my lord. 1 to 5, accused number 1 to 5.
Want to file
1 to 5.
14th June.
They have not filed their counter.
14th June we are giving.
You, my lord, my senior is out of station due to family
But,
emergency.
you cannot
So-
wait for your senior to come back. We have given a date to you. You have to
No,
comply
my
with
lord,
the orders.
on Monday we will file, my lord. Due
You
to
have
family.
given lot of time now. In the meanwhile, comply with the order and submit the compliance report, serving copy thereof on the council.
Oh, we'll submit on Monday, my lord. Yes,
After
After, okay.
My lord, for accused 6, 7 and 8, you have to await notice, my lord.
A62. A62. Fresh notice has to be issued. Say fresh notice. Reminder notice. Earlier notice.
there shall be a reminder notice to.
Reminder notice. To the Director General of Police in Telangana.
R6 to R6, R7
Very well.
returnable on same date.
Thank you.
14 June. Number 36.
This case may not die.
Sir,
Very for the-
Rajaram is-
Please, respondent number 2, my lord. This case, this honorable court was pleased to file further affidavit, complaints affidavit. my lord.
Maybe further update you have brought now.
Yes, ma'am.
Have you served a copy? Consider the representation.
Yes, ma'am.
It's considered.
It's considered and my lord, there is no seepage.
This
And
is the
there is
same
no
matter
question
where you
of
are saying that
rehabilitation or.
there is no, they are not affected.
They are not
No,
affected.
no, my lord. They are growing coffee, arecanut and they are having pakka residential houses and all.
Still Pakka officer.
They are saying like that, why they will lie?
They have
How to
produced
challenge
photographs
before the
also.
single
They
judge.
have produced photographs.
Photographs. Where is the reply? Affidavit, yes.
Two
Starts
two
from-
affidavits are filed by us, and R1 we have filed on 15/2/2000.
Who will pass the order? Some portion of the affidavit report.
There is compliance.
Please.
Compliance.
Compliance.
There is compliance of the
Yes,
order.
yes, my lord.
Compliance.
Complaint.
Compliance. Civil.
If you have any grievance, so liberty will reserve and you can work.
Please.
Number 37. Muniswamy Gowda H.
Thank you.
Okay, for respond.
Page number 31 is the order, my lord.
My lord, my counter in page number 19, my lords.
Page
My
number,
counter in page number 19, my lords, matter is pending before Supreme Court. Honorable Apex Court has issued notice to the
Notice has been issued.
19, my lord, 19. I produced the, my lord, record of proceedings.
my lord, this order was passed on 27th July 2022. Till today, there is no interim order.
So there is a
23, my lord.
Apex Court is examining the issue. We'll give some time and July we can call this.
9 July.
9 July.
38 urgent, number 39. Mr. Vijay Kumar SC.
Court is not.
The police have not. Then you have to call the commissioner here. So Davangere Police.
Yes. Ma'am. I'll seek instructions. I'll seek instructions. for the matter.
Now you give instructions rather taking. Otherwise, we will give it. Calling the SP or whatever comes. SP of the district.
Davangere SP, he is not serving these copies. We are not asking him to chase some thief and bring him here. We are saying, take our papers, serve a copy on the accused.
I understand.
Even that they do not.
Will convey.
Report on 90.
Please.
We stand evinced on behalf of the police authorities is that the service of the summons of the court is not effective, would not be effected by the police on the private persons. Such stand is not acceptable, neither acceptable nor believable. Full stop. Learn that government council has taken the instructions in this regard and apprise the court about the correct situation of the case. Correct situation. Full stop. 19, stand out to 19 to be listed at the report.
Number 40, Nayak VS.
Process will be paid within
In
1
this
week.
matter, corporation has
Failing
preferred an
which
appeal.
the Contempt
Writ appeal
complaint will be
160.
automatically dismissed. Will automatically stand dismissed.
Number 41. Mr. Vishwesh, yes.
Yes, only 10 matters.
Yes,
Yes, number 41.
nobody is there.
Proceedings are complete.
Process fee to be paid within 1 week, failing which the whatever appeal is shall stand automatically dismissed.
Number 42.
For appellants in the second matter.
Service is incomplete.
Fresh
Learned
process.
advocate for the
Fresh process
appellant
you
to
have to
take
take.
steps to.
But this
effect
is a
this
matter,
action.
Lords, I must only bring to Lords' notice. We have lost land 5 acres without acquisition. And the state has confirmed that our land is taken away without compensation or without any other sort of restoration. Learned single judge holds, Lords, on admission by the government that this land is taken away from the petitioners. And therefore, Lord, he directs restoration of possession. This is the position. My request is, Lord, if after vacation, one date may be fixed to examine this issue, Lord, I'll be grateful.
Process they have to take, process steps.
This has been last several occasions, they have not.
Otherwise, it stands dismissed.
Connected several.
Peremptory
I'll
orders.
leave.
42.2 for the appellant. The cases have filed a memo to the extent that all the responses are being served.
That's interim order has to be extended, my lords.
It is complete now.
42.5 also.
That's interim order has to be extended, my lords.
With my lordship, kindly.
Wherever it is there, it will be continued.
Much of like.
But my request is an early, some date after vacation.
It will be. Yes.
With my lordship, one tender matter, my lords, your lordships, where Mr. Holla had appeared, the judgment copy of the learned single judge was not available, my lords. Lordship were pleased to grant a stay and said post immediately after the judgment. We have filed the judgment, but the appellant has not filed the judgment. There's office objections. We are not able to get the matter listed, my lord.
You have filed the judgment now.
We have filed, my lord, while till they're not. Well, it is for them having obtained an interim order, they should have complied, they should have.
Application for amendment. Along with that, my lords, the order is placed before my lords. I don't see the reason why.
Solid.
Monday we are posting.
Monday we are posting.
Very
this.
well, my lords. Monday.
Please, I'm grateful.
My lords, my lords, one intelligence.
It is today listed.
Serial number 3,
Not
my
listed,
lords,
no.
has disposed of the matter. My lords, notice should not be precipitated by the respondents. Further proceedings, my lords. Dismiss the writ petition, my lords, with liberty to file a review petition and objection to the notice, my lords. Let them not precipitate till my objection is considered, my lords.
3. No, we have passed the order. Already dismissed the petition.